It's here, everybody. It's here. It's here. It's here. It's here. It's here. It's here. Okay. It is here, you guys. Okay. So without further ado, the government has responded. Okay. Normally I go through my whole little spew, my whole little banter, but I'm not going to do that. We're going to go ahead and get into it. Okay. I am super excited. This is what we've been waiting on. Okay. So let me get everything pulled up. Okay. Let me get everything pulled up. Let me make sure. Sorry, y'all. I was just making sure that you guys can hear me okay. All right. The response is in. Okay. So let me, okay, let me do this. Okay. Now let me share my screen. Okay, let me share my screen. This is what we've been waiting on, you guys. The government's response. Okay. All right, you guys, let's go ahead and get into it, okay? This is it. This is it, y'all. The government's response to defendant's motion for a new trial pursuant to Rule 33 of the Federal Rules of Criminal Procedure, okay? So they have not yet responded to the acquittal, okay? What we are reading is just a response to the new trial, okay? All right, so this is what we're about to hear, the introduction, okay? Acceptable law, okay? Hold on, y'all. Okay, sorry, y'all. Okay, all right, let me see. Okay. All right, y'all, let me put myself off the screen, okay, so you guys can see it, okay? The defendant was not denied effective assistance of counsel. Okay, let's go. Let's go ahead and get into it, okay? I want to see what they have to say, okay? These are the table of contents where they got all their laws and regulations, okay? So let's go ahead and get into it, okay? The introduction, the defendant seeks a new trial pursuant to Rule 33 of the Federal Rule of Criminal Procedure, Rule 33, as a result of his conviction on September 27, 2021 of 9 counts, charging racketeering and multiple violations of the Mann Act. In this motion and supporting memorandum, okay, the defendant argues that he, one, was denied effective assistance of counsel because his trial attorneys failed to conduct a meaningful voir dire of potential juries and challenge unqualified jurors. And two, was denied conflict-free counsel under the Sixth Amendment because one of his attorneys simultaneously represented, okay, and they put that ED for past tense, the victim who testified at trial under the synonym Jane, okay? For the reasons set forth below, the court should deny the motion in its entirety. Let's get into it, okay? All right, so the government goes ahead and says Rule 33 provides that the court may grant defendant's motion for a new trial if the interest of justice so requires, okay? However, motions for a new trial are disfavored in the circuit, and the standard for granting such a motion is strict. Okay, and this is the legal thing right there. Okay, accordingly, courts must exercise their Rule 33 authority, okay, sparingly and only in the most extraordinary circumstances. Okay, so basically saying like, child, girl, you trying to sit up here and say that, you know, he needs a new trial, you know, but this is not an extraordinary circumstance, okay? Goes on to say the defendant was not denied effective assistance of counsel during the voir dire. The defendant asserted that he is entitled to a new trial where his trial team conducted no meaningful voir dire and acquiesced to the seating of jurors who were unqualified to serve as this jury. This claim lacks all merit. Come on, government. Relevant background. In order to facilitate jury selection in the case, approximately 575 prospective jurors completed a comprehensive 28-page questionnaire. Didn't I tell y'all that? I said the questionnaire is extensive. And I also told you guys that while people, you know, on the opposite side and thereof were like, oh, well, oh my gosh, you know, and I said, no, y'all, let's listen to see what they were saying in regards to questionnaire. Y'all, I looked at the questionnaire. The questionnaire was extensive, okay? It comprised of 108 questions. I told y'all. The court then invited the parties to submit challenges to any prospective jurors based on their questionnaire responses. The parties thereafter submitted a joint list of 251 prospective jurors they agreed should be stricken for cause. Well, boom. Right there. And I thought so. I thought that's what I read. Okay? I thought that is what I read. All right? 251 prospective jurors, they agreed should be stricken. I saw that. I saw that they stricken some people. In addition to the agreed upon 4 cause challenges, the government submitted a list of 34 additional prospective jurors in challenge for cause for various reasons. And the defendant submitted a list. Okay? You hear that? Not only did the attorneys submit their issues, but the defendant, R.KELLY, submitted a list of 145 additional prospective jurors he challenged for cause for various reasons. The court then directed the remaining prospective jurors who were not challenged for cause by either party based on their questionnaires to appear for an in-person voir dire. Okay? Over the course of 2 days, the court conducted an in-person voir dire in 2 phases. During the first phase, the court addressed the prospective jurors in a group setting, advising them of multiple principles of law, including the burden of proof, the defendant's presumption of innocence, and the need to follow the court's instructions. Okay? Now, during the second phase, the court spoke with the remaining prospective jurors individually, outside the presence of the other prospective jurors, making further inquiries of each prospective juror. See, this was intensive. This was thorough, okay? This was thorough. This wasn't just no fly-by-night situation. They went thorough with each one of these jurors. Baby Bojangles, you met your match, child. Including posing additional follow-up questions submitted by the parties and writing and orally during voir dire. During in-person voir dire, the court excluded approximately 34, so they still was knocking them down. Prospective jurors for a cause for various reasons, including scheduling conflicts, English comprehension issues, financial hardships, and concerns about the prospective jurors particularly. Okay, and here goes the numbers, I guess, of the numbers that they got rid of after voir dire. Oh yeah, it is voir dire. There it go. Yep, this is, I guess, who they're talking about that they got rid of, or whatever the case may be. Now after this, okay, it says. They completed after they completed, the parties exercised their premonitory challenges, okay, from that little pool, all right, of qualified prospective juries in the court. Subsequently seated and sworn 12 juries and 5 alternative juries to hear the case. So, baby girl, that's ruled out, that's marked off, or more so, that's explained, shall we? Girl, see, child, let's go. I can't wait to hear what they say about the acquittal. And that'll be the text messages everybody's crying about. Anyways, let's continue. Following the close of evidence and the court's final instructions, the 12 jurors deliberated, ultimately finding the defendant guilty on all 9 counts in the third superseding indictment. With respect to Court 1, which charged the defendant with racketeering, the jury found that all racketeering acts except racketeering acts 3 and 4 have been proven by the government. None of the alternative jurors was called on to deliberate, meaning these were the original ones. Okay, now legal standard. Let's get it. A defendant who attacks his conviction based on claims of ineffective assistance of counsel must, 1, show that counsel's performance fell below an objective standard of reasonableness under prevailing professional norms. 2, okay, affirmatively prove prejudice, i.e., demonstrate that there is a reasonable probable that, but for counsel's unprofessional errors, the result of proceeding would have been different, okay? And this is the statute right here of the law, okay? Goes on to say, 1, that counsel made error so serious that the defendant was deprived of reasonable competent representation. And that 2, that counsel's deficient performance prejudiced the defense. Okay. Now, both prongs must be satisfied. To succeed on an ineffective assistance claim, and the court need not address both components if a defendant fails to establish either one. As a failure on either showing is dispositive. Okay. All right. Deficient performance. Now, with respect to the first prong, a defendant must identify the acts or omissions of counsel that are alleged not to have been the result of reasonable professional judgment. Now, the court must then determine whether, in light of all the circumstances, the identified acts or omissions were outside the wide range of professionally competent assistance. Okay, this law right here. Now, judicial scrutiny of counsel's performance must be highly differential, and strategic choices made through investigation of law and facts relevant to plausible options are virtually unchallengeable. Okay, and that's stated in this particular law. Okay, moreover, Evaluating counsel's performance must not serve as an opportunity to act as a Monday morning quarterback. All right. Y'all remember that's what she used. Okay. So they threw it back in her face. Okay. It goes on to say, finding that the performance inquiry examines the reasonableness of counsel's actions under all circumstances, keeping in mind that a fair assessment of attorney performance requires that every effort be made to eliminate the distorting efforts of hindsight. Okay. And it's quoting in this particular law. Rather, a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances, the challenged action might be considered sound strategy. Okay? So what they're saying is that we can very well say that, well, this was strategy. Come on. Yeah, let's go. Y'all, I hope y'all getting that. Okay? I hope y'all getting that. So what she is saying is that what the government is saying is that, baby, we can say that this is strategy. Okay? We can say by y'all doing what y'all doing or what y'all did on trial was strategy. So now y'all can come back and do this. We can say that that's strategy. Come on, government. Y'all better act like y'all know. You better act like you know. Okay? Rather, a court must indulge a strong presumption that counsel's conduct falls within the wide range of reasonable professional assistance. That is, the defendant must overcome the presumption that under the circumstances, the challenged action might be considered sound strategy. And this is the law right here. The Second Circuit has defined a strategic decision as a conscious, reasonable, informed decision made by an attorney with an eye to benefiting his client. Okay, goes on to say this. All right, internal citation and quotation marks omitted. Now, when examining an ineffective assistance claim in the context of jury selection, consistent with Strickland, an attorney's actions in conducting voir dire are also afforded difference. Difference. And this is the law right here. Indeed, courts are loath to second guess the decisions of counsel during jury selection. Okay, as stated in here. Now, strategies as to the exercise of peremptories are matters of counsel's intuition and do not rise to the level of constitutional violation. Come on now. So basically saying that what you're saying is like, how can we say if it's ineffective or not? That's basically what she's saying. How can we say that it's ineffective or not when everybody is basically to each their own? You know what I'm saying? How can we say that your stuff is wrong when how you conduct your voir dire may not be like mine? You know what I'm saying? So that's basically what they're saying. Okay, let's continue. It is not the role of the court to second guess counsel's reasonable strategic decisions at jury selection. Remember they were saying, well, the judge was supposed to on this act, because this was, I can't remember where we heard this from, but basically they were saying that it was up to the judge at some point to make this decision for R.Kelly because this was an attorney, this was a situation that couldn't be thrown out. Remember that what was going around? What they're basically saying, it's not up to the court to make this sound decision for him, especially when they were asking multiple times, is this what you want to do? Come on now, don't play with the government. Goes on to say, this is good. It says and made all significant decisions in the exercise of reasonable professional judgment. Oh, sorry. Let me read that over. It is not the role of the court to second guess counsel's reasonable strategic decisions at jury selections, okay? Especially considering that counsel is strongly presumed to have rendered adequate assistance and made all significant decisions in the exercise of reasonable professional judgment. So basically, again, saying that we don't know your plans. So now you're saying because you didn't win, it wasn't a good one. Oh, come on now. Government is pinning it to her behind. All right. Goes on to say, an attorney's action during voir dire are considered to be a matter of trial strategy and cannot form the basis for an ineffective assistance claim unless counsel tactically decisions are so ill chosen that they permeate the entire trial with obvious unfairness. And it wasn't, y'all. They were grinding these they were pinning it to these to the witnesses. Okay, so you can't claim ineffectiveness. You can't claim that now because you lost. Okay, come on. Let's go. I can't wait to see what they do about the acquittal. Again, you guys, this is all pertaining to the new trial. Okay. All right. Goes on to say, additionally, if a defendant fails to demonstrate that he requests that his attorney exercise a preparatory challenge for particular juries, the petitioner is deemed to have acquaintance to the attorney's decision not to do so. Okay. And then this is the law. Okay. All right, this is what they're saying, okay? Goes on to say, all right, holding that the defendant's acquiescence of trial counsel's strategy decision amounted to forfeiture of defendant's right to assert constitutional infirmities, okay? Prejudice. Baby, they are attacking everything. So maybe that we will, fingers crossed, prayers up. I ain't gonna lie to you. Maybe we will hear in regards to every detail of the acquittal pertaining to the text messages, okay? Because in this new trial response, they're attacking everything. So maybe we will actually hear in regards to those text messages, but no promises here. Let's continue, okay? All right. Prejudice. Now, this may be a lengthy video because it's a lot of pages. With respect to the second prong, an error by counsel, even if professionally unreasonable, does not warrant setting aside the judgment of a criminal proceeding if the error had no effort on the judgment. Okay, that's what she said. Okay, now they quote from Strickland. Okay, thus, to establish prejudice under Strickland, the defendant must show that there is a reasonable probability that. But for counsel's unprofessional errors, okay, the result of the proceedings would have been different, all right? A reasonable probability is a probability sufficient to undermine confidence in the outcome, all right? Strickland. Now, a court must review the prejudicial effort of counsel's errors in the aggregate. Okay, this law right here. Unlike the determination of trial counsel's performance under the first prong of Strickland, okay, the determination of prejudice may be made with the benefit of hindsight, okay, and this particular law right here, okay, to establish prejudice stemming from trial counsel's failure to challenge a prospective juror for cause during voir dire, a defendant must establish actual bias. Oh, come on, somebody. Oh, yeah. Okay, so you gotta actually establish, oh, that particular juror was being biased. I told y'all it was more questions that was asking. That lady picked apart what she wanted to. I told y'all gonna listen to me one day. No different from these text messages. And I did my research. So if they don't talk about it, you're going to hear from me. And this ain't no inside job. This is just me reading like y'all should have been reading and paying attention to fine tunes. Okay, but we're gonna talk about that when we get on the acquittal part. Okay, but we're gonna get back into this. This lady picked apart different jurors and just threw it. Didn't pay attention. 100 and I think it was 120 something, 132 questions, y'all. I told y'all she picked 5. Where they do that at? Let's continue. That's why evidence over emotions over here. Okay, let's go. Okay, let's continue. Okay. However, to maintain a claim of ineffective assistance of counsel based on the failure to object to a biased juror, the petitioner must show that the juror was actually biased against him. Okay, again, see why you can't just run with one side. We heard all of that about the jurors. Everybody, oh, he needs a new trial. Oh, he needs to be freed. Oh, really? But now, see, we hear the other side of that. And now you're thinking, oh, wait a minute. She didn't prove anything. Well, why do you say that this particular juror is biased? Can you go to the conviction and show where in the notes? Because they do got juror notes. I hope y'all know that. A lot of it is sealed. But for the most part, you see what the jurors wrote down and why they went with what they went with. And see, in those particular notes that the attorneys are privy to, why didn't you put them notes with that particular juror and say, this is the reason why? Oh, because she wasn't there in court and she didn't have time to go through all of that. But we got time. All right, let's continue. All right. So that's what that's saying. You didn't show any actual bias. Yeah, you threw some questions out there and some answers, but you didn't show any legitimate bias with that particular juror. Now let's keep going on. Okay. Approximately 2000. Okay, so that's that particular law. Based on the lack of actual or presumed bias of the jurors, the petitioner has not demonstrated he was prejudiced by his counsel failure to strike these jurors and has therefore failed to establish ineffective assistance counsel. And again, with him talking about his counsel being ineffective, where they still executed your rights. No way, shape, or form was his attorneys not doing what they could on behalf of him. But nigga, you had so much evidence. What are we talking about? Nobody could save you. Nobody at all. Let's continue, shall we? Come on. Y'all better stop playing with the government. They are not one of them. Okay, let's continue. Goes on to say, actual bias is bias, in fact, the existence of a state of mind that leads to an inference that the person will not act with entire impartially. And they did. Okay? Actual bias can be found where a prospective juror admits particularly, or where the same can be inferred from his or her answers to voir questions. Okay. Example. Okay. Significantly, even where a juror expressively doubts his or her impartially or voir a finding of actual bias is not automatically mandated. Okay. So just because they responded a certain way or a particular way, it doesn't mean, oh, no, they can't be on trial. They can't be jurors. You idiot. That doesn't mean nothing. I mean, they're answering a question. But what other questions were asked? Come on, let's continue. Sorry, y'all. Holding that ambiguous and contradictory story or testimony of 3 jurors was insufficient to overcome presumption of correctness owed to trial court's findings that the jurors would be impartial. Now, the test for determining jurors' bias is well established. Okay, to hold that the mere existence of any preconceived notion as to the guilt or innocence of an accused without more is sufficient to rebuke. Okay, the presumption of a prospective jurist in partition and partially would be to establish an impossible standard. See, I said that. Didn't I tell y'all that? I told y'all. I said was no way in shape or form that they were just going to find squeaky clean jurors. You're not going to find that. It don't exist. You're bound to have somebody who watched the Surviving R. Kelly or heard about it. I said that. But what do little old lazy Whitney know? Let's continue. Nope, the government is not playing with them. Okay? It is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. Okay, this particular law, all right? Even where a juror previously expressed some reservations about his ability to be fair and impartial, if the juror later expressed during voir dire that he will try to decide the case based on the evidence presented, that assurance is generally sufficient. Wow, see? Because she tried to throw that out there, I'll try, as being a bad thing. It wasn't a bad thing. He said, I would try. He was being honest. And like she said, hey, Brooklyn, like she said, it was sufficient in a lot of cases. They tried. Come on now. Let's go. Okay. It goes on to say, therefore, to prevail on a claim that defense counsel was ineffective in failing to remove or challenge a juror during voir dire, a defendant must show that the juror was actually biased against him. Okay? Without a finding that the juror was actually biased against petitioner, prejudice under Strickland is not presumed. Oh, come on now. She said, that's a no bueno. Okay? Analysis. The defendant's ineffective assistance claim are wholly without merit. He cannot establish either prong under Strickland, and his motion should be denied. Now, the defendant first makes generalized assertions that trial counsel failed to conduct any meaningful voir dire of prospective jurors to ensure they were free of bias or prejudice. Okay? Now, 2, unfound and vague claims that trial counsel should have, for example, probed more deeply, inquired further, or completely questioned certain jurors. These claims are wholly belied by the record. Child, they are giving it to them, okay? Which shows that trial counsel actively participated throughout the voir dire process. I thought so too. Submitting additional questions. I said that. I said, didn't they submit additional questions? Come on now. And asserting challenges for cause both in writing and orally. And see, because Bojangles wasn't here, she probably didn't recall all of that. Yeah, see, I remember the transcripts. I remember going to the doc and I was like, but they were submitting additional questions to be asked. And they were striking stuff right here. But what is she talking about? That the jurors and the people on the other side, he need to be free because these jurors. In some cases, successfully asked to various prospective jurors, including those prospective jurors whose impartially may have been in question. In addition to the defendant's written for cause challenges, With respect to approximately 50 prospective jurors initially qualified after the first 2 days of in-person voir dire. So meaning, okay, even after they broke everything down, they had 50 prospective jurors that qualified, that they still combed through even further after that. Okay, the defendant requested that the court make further inquiries of approximately 19 prospective jurors. So even in the 50, out of the 50, 19, they were still asking additional questions too. So where in there with the jurors you had inadequate counsel, bruh? You didn't. Come on. Yes. Goes on to say, including additional questions related to the prospective jurors, opinions on the Me Too movement, and related topics, as well as their knowledge of the defendant and the nature of charges. And it showed right here. Okay. Now, on various occasions, after hearing certain prospective jurors' responses to the follow-up questions, trial counsel did not challenge them. However, with respect to certain other prospective jurors, okay, for example, prospective jurors numbers 120 and 182. Ooh-wee. Now they're showing examples. Okay. Defense counsel challenged and court ultimately excused the prospective juries for cause based on their responses to inquiries related to Me Too movement. Okay. So basically she's saying, you ask questions, get particular jurors thrown out, and that was done. Child, come on now. Let's go. All right. Okay. Goes on to say, trial counsel inquiries on these topics clearly reflect that they consider the very issues now raised by the defendant when making for cause and peremptory challenges and made strategic decisions in certain instances, not to challenge a particular prospective juror based on their responses to inquiries from the court and parties. Okay. Now, reasoning that the fact that trial counsel's decision not to challenge a juror for cause was strategic may be evidenced by trial counsel's use of for cause challenges on other prospective jurors. Okay, this is what this claim is right here. Okay, now finding that counsel's active participation in voir dire indicates that any decisions to challenge or not to challenge jurors were made as part of a reasonable trial strategy, rather than as a result of counsel's failure to provide effective assistance. Okay. Now, rejecting ineffective assistance of counsel claim regarding voir dire because the record reflected that defense counsel was actively engaged in the voir dire process, and an attorney's determination to accept or strike a prospective jury was a strategic or tactic decision. Okay. Now, goes on to say, finding that counsel's decision to peremptorily challenge 8 jurors lent support to conclusion. That decision. Thank you, Shay. Thank you for the Cashapp donation. Thank you so very much for your donation. Hold on, y'all. I know we're reading, but hold on 1 second.
Shit. Not none, dog. A store like that.
I ain't got none.
I want a cookie.
Ain't got none.
I want a cookie.
Ain't got none.
I want a cookie, yeah. I want a cookie.
Ain't got none.
Stupid.
Thank you again, Shay, for your cash out, your donation. All right, it goes on to say that finding that counsel's okay, I already read that part. Okay. So down here it goes on to say counsel exercised 2 peremptory challenges for other prospective jurors during voir dire. Okay, this suggests that counsel deliberately chose not to challenge another juror as part of trial strategy that might be considered sound. Okay, again, what you eat don't make me crap. Okay, how you move may not be how I move. That's what the government is saying, and that is true. Okay, just because maybe I wouldn't do it that way and you did, that's just how you do it. So you can't sit up here and say now, oh well, because they did it this way. No, no, no. It don't work that way. Okay? It don't work that way. And so that's what they're saying. Okay. All right, let's continue. Okay. Nor has the defendant shown that he suffered any prejudice. He provides no tangible evidence of actual bias, relying only on speculation based on the challenged jurors' responses during voir dire as perpetrator evidence of bias. Now, and therefore he has not he was not prejudiced by trial counsel's failure to challenge them, where petitioner offered no evidence beyond the voir dire testimony of 3 individuals as to how the jurors were biased. That's what I said. Okay, she picked out of 12 jurors 3 and a few questions from them to prove her claims. Other than speculation regarding these jurors' ability to be impartial, given that each of the jurors at issue asserted their impartiality, and that they could fairly decide the case. Indeed, the very fact that the defendant asserts the trial counsel should have uncovered some additional imagined information, but produces no actual information supporting the claims. Bias emphasizes the speculative nature of these claims. In addition, the defendant's claims regarding trial counsel's failure to challenge prospective jurors who, one, had some knowledge of the defendant and or the allegations against him, including through affirmative responses to question 31, indicating that they watched or heard interviews of Robert Kelly, TV shows referring him, or specials or documentaries about him, knew of the Me Too movement, or also lacked merit. As the Supreme Court has made clear, qualified jurors need not be totally ignorant of the facts and issues involved. This nimwit, this dodo bird, just disregarded that law. And I told y'all gonna stop playing my face. I said it's impossible for them to find no one that was privy to this law. It's impossible. How, Sway? How are they gonna do that? How? Let's continue. Okay, let's continue. And yes, we did. I did a whole video on all the members. I did shout them out. Okay. Every case of public interest is almost, as a matter of necessity, brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted for jurors who has not read or heard of it, and who has not some impression, or some opinion in respect to its merits. Right. If you're saying that this district of people is the only whereabouts where we're going to get jurors, you're bound to find someone that is privy to this information. Most cases, pre-trial publicity, even pervasive adverse publicity, does not inevitably lead to an unfair trial, just because they're privy to that. Rejecting an effective assistance claim, finding that defense counsel's decision not to challenge a juror was within the realm of sound trial strategy, and that defendant could not establish actual bias, where police officer juror advised where am I at? Advised he could have had personal knowledge of the facts of the case in his employment, but did not recall any such knowledge and could remain impartial. Further, the defendant's unsupported assertion that the jurors own subjective assurance that they could be fair was not sufficient to ensure that they did not harbor beliefs or preconceived ideas about defendant's guilt flies in the face of both the record and binding legal precedent that it is sufficient if the juror can lay aside his impression or opinion and render a verdict based on the evidence presented in court. And that's all it's about, people, the evidence. As set forth in further detail below, the defendant has objectively failed to prove that trial counsel did not act strategically in deciding not to challenge certain jurors for cause or use peremptory strikes to prevent their selection. Now, he also fails to show that any of these jurors bore actual bias against the defendant. Now, he therefore cannot show deficient performance or prejudice. Jury number 3, formerly prospective juror number 25. The defendant asserts that trial counsel was ineffective in failing to challenge juror number 3, given his responses that he had seen a documentary about the defendant and his legal troubles and heard that he has been sleeping with underage girls. Now, as noted above, the mere fact that a juror has knowledge regarding the defendant or aspects of the charges does not automatically create a presumption of bias, particularly whereas here the jury has indicated that he can set aside his prior knowledge and decide the case based solely on the evidence presented at trial. Come on, somebody. Woo, this is good. Hey, y'all. Hey, Taver. Hey. Hey, West Coast. Hey, Karen. Y'all, this is good. Okay? All right. Indeed, the defendant completely ignores, as he does with each juror's affirmation of, in particularly juror number 3's unequivalent statements, both in response to the questionnaire and during in-person voir dire, which reflect a total lack of bias and the clear ability to be impartial. For example, in question 2, for example, in response to question 31, the juror number 3 advised that he had seen a documentary about the defendant, but added, "I don't know the full story." Man, say, y'all see what this woman did? Y'all see this? And y'all gonna stop playing in my face, all right? Y'all gonna stop playing with me. This is the reason why I don't just run with one side. She grabbed a little snippet of an entirety of something, but the government is putting it all out there. Oh, no. Since you want to talk about that juror, you said this, but he also said this. Come on now. Let's go. Oh, yeah. Let's go. I don't know the full story, so I have no feelings about it. I remain impartial. Question 31 emphasized added, okay? Moreover, in response to question 32, which asked whether he had an impression of the defendant based on what he had seen or heard, jury number 4 advised that his impression was neutral, adding that the media tends to demonize people. I deal with facts. Come on, somebody. Y'all gonna stop playing in my face. Always gonna be evidence over emotions over here. You can't just run with a little snippet of something. Because you get egg on your face, people. Y'all keep listening to the other side if you want to. I'm just say that like that. Okay, let's continue. I deal with facts. I do too, juror number 3. Question 32. Juror number 3 said also advised that he had not overheard discussion about the case, nor had he discussed the case with anyone or online. Okay. Juror number 3 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with his ability to decide the case fairly and impartially in accordance with the court's instructions. Now, with respect to questions regarding the so-called Me Too movement, juror number 3 indicated that he was aware that the movement seeks justice for rape victims 23 through 30 years after the fact. And also, come on now, put that also in there. And also indicated he had no reason to believe he could not apply the law that the defendant is innocent until proven guilty, and the government bears the burden of proof. During in-person voir dire, juror number 3 further affirmed his ability to be fair and impartial. When asked whether there was any reason he could not follow the court's instruction regarding the burden of proof and the fact that the defendant was innocent until proven guilty, juror number 3 responded, no reason at all. When asked by the court whether there was any reason why he would not be able to follow the court's instructions on the law, juror number 3 responded, no. I'm a stickler for the law on my job. I'm the rule guy. Now, do you see why you can't just get half-ass information? I told y'all, the defense job is to make the other side, particularly the prosecution, whoever's on there, parents, victims, witnesses, look bad. Oh, but it's always the bigger picture. That's why I keep my mouth shut. Let's continue, shall we? Moreover, jury number 3 answered that there's no reason at all why he could not follow the court's instruction not to research the facts, law, or people involved in the case. And when asked by the court, is there any reason at all why you wouldn't be able to give both sides a fair trial? Juror number 3 again unequivocally answered no. In these circumstances, okay, hold on. Sorry, y'all gotta change out these things real quick. Child, this is good. Sorry, y'all, I had to change out my ready. Where were we? Okay. All right. In these circumstances, the defendant cannot show deficient performance in counsel's decision not to challenge juror number 3, and also fails to prove any actual bias on juror number 3's part that will result in prejudice failing both Strickland prongs. I told y'all, man, I said, y'all, it was so many other questions that were asking. Let's continue. Sorry, y'all, excuse me for these belches. Indeed, it was clearly sound strategy on the part of the trial counsel to not exercise a premonitory challenge. Juror number 3 explained in his questionnaire that he had been arrested on 2 occasions, which resulted in charges being dismissed. And during the collude with the court, empathetically expressed that he had previously had certain negative experiences with law enforcement, and that while he was not biased against law enforcement, he was biased against people in law enforcement that do these things. Thus, trial counsel likely made the strategic decision to keep Jordan up. I said that. Okay, I said that. I said maybe it's some balancing other questions and answers to this. And it was, as we were reading. They believe the jurors' past negative experiences with law enforcement, including being falsely arrested twice, coupled with his belief that the media demonizes people, question 32, would make him more critical of the government's case. Trial counsel may also have reasonably believe that the government might use a peremptory strike on jury number 3, given the government's follow-up questions, which trial counsel may have interrupted as a concern regarding juror number 3 on the part of government. Okay, this law right here, rejecting claim of ineffective assistance of counsel, where defense counsel did not object during voir dire process because, among other possibilities, counsel, among other reasons, failed to object so as to force the prosecution to expend an additional peremptory challenge to strike the juror. Okay, now juror number 4, formerly prospective juror number 52. The defendant next claims deficient performance due to trial counsel's failure to challenge juror number 4 based on the juror's questionnaire that the juror finds transmission of STDs in a non-consensual act to be particularly repulsive. I remember that. Has a close friend who was a victim of sexual assault and listed the person he least admired as Jeffrey Epstein. I remember that. Again, the defendant fails to carry his burden to establish either Strickland prong. Jury's number 4's questionnaire and voir dire response in no way amount to actual bias against the defendant. A juror is not required to have entirely neutral feelings about the particular types of crimes charged. Okay, this particular law right here, denying post-conviction relief and finding trial counsel's decision not to challenge prospective juror in narcotics trial who expressed views about dangers of drug use given family history of drug abuse was not deficient performance. Okay. Where juror affirmed ability to be fair and impartial after court advised juror that nobody is asking you to walk in here toe blank. You will bring in your life experiences, and that the relevant question was only whether juror could follow the law as I give it to you, and will you be fair and impartial. Rather, the central issue is whether the juror can lay aside any preconceived notions. Okay, this one right here. Here, juror number 4 indicated that he could. Okay, nor was bias established on the ground that juror number 4 knew an individual who was a victim of sexual assault, notwithstanding that the charges against the defendant involved sexual assault. Okay, see here. Now, finding that bias could not be inferred, where jury advised the court that, among other things, his wife had been abused before they were married. In case involving prosecution of defendant for forced labor of 2 young girls. Importantly, in response to question number 37, which asked whether there was anything about the nature of the charges in and of themselves that would prevent the juror from deciding the case fairly and impartially. In accordance with the court's instructions, jurors number 4 responded no. Likewise, in response to question 36, which asked if there was any reason why juror number 4 could not apply the law that the government bears the burden of proving the defendant guilty beyond a reasonable doubt on each charge, juror number 4 responded no. In fact, as was evident from juror number 4's questionnaire and in-person voir dire, juror number 4 had very little knowledge of who the defendant was, confusing the defendant's alias R.KELLY with a famous cartoonist from decades earlier. Even upon clarification that the defendant was not the cartoonist, juror number 4 had very little knowledge of the defendant and had seen some news articles that did not appear to have made any impression on him. When asked whether there was anything that juror number 4 had read that would affect his ability to be fair and impartial in the case, he responded, "Not that I know of." Okay, man, say they're getting it all together. Okay, hey, you guys, sorry I'm not able to see you in the chat. I'm trying to get this, push this out for you guys. Got a few more pages. Okay. Moreover, when the court spoke of the duty of jurors to decide the case based on the evidence at trial, juror number 4 added that the case was to be decided by the evidence, testimony, and your instructions on the law, clearly demonstrating his understanding of his duty as a juror. Okay. Okay. Jury as juror. Okay. When the court advised juror number 4, that the government bore the burden of proving the defendant guilty beyond a reasonable doubt, juror number 4 responded right and stated that he would have no problem following the court's instruction that the defendant is innocent until being proven guilty. Okay. Therefore, any potential concerns that may have arisen from juror number 4's questionnaire responses were irrelevant by alleviated by juror number 4's clear responses in the questionnaire and during voir dire that he could remain fair and impartial and decided the case according to the court's instructions. In these circumstances, the defendant cannot show either deficient performance or actual bias, and his claim should be rejected. Boom. Juror number 5, formerly prospective juror 87. Okay, let's go. Okay, let's go. All right. Okay. The defendant claims that trial counsel should have challenged juror number 5, okay, because she had some knowledge of the defendant and had a somewhat negative impression of him. In response to why juror number 5 had this impression, juror number 5 wrote that there was an allegation that related he was sleeping with underage girls, minors. Notably, juror number 5 specifically used the word allegation. And that means that he didn't believe it. I'm just, just saying, okay? Goes on to say, notably, juror number 5 specifically used the word allegation to describe whatever knowledge she may have had about the case. Despite being aware of this allegation, which is no more than was included in the summary of the case provided as part of the juror questionnaire, juror number 5 advised that she had not overheard any discussion about the case, discussed the case with anyone, or posted any opinions online. Juror number 5 further responded that neither the defendant's celebrity nor anything about the nature of the case would interfere with her ability to decide the case fairly and impartially in accordance with the court's instructions. During the in-person colloquy, the court asked juror number 5 whether, despite having some familiarity with the familiarity, I think, with the case, juror number 5 was able to put aside anything that juror number 5 had heard about the case and just judge it on the evidence that you hear in the courtroom. Juror number 5 responded, yes. Child. The court asked a second time, stating, okay, and put aside all those other things you might have heard. To which juror number 5 again stated, yes. Shortly thereafter, the court asked jury number 5 whether there was any reason she could not follow the court's instruction that the defendant was innocent until proven guilty, and that the government has the burden of proving the defendant guilty beyond a reasonable doubt. Jury number 5 again responded, no. In response to the court's inquiry as to whether the jury was hesitating a bit in her answer, jury number 5 stated, no, there wouldn't be no reason that I wouldn't be able. Where I work, you have to. Where I work, we have to follow the order. In response to the court's further questions regarding whether jury number 5 would follow this important principle of law regarding the burden of proof and would follow the court's instructions on the law, jury number 5 said yes to both. Now, during this portion, of the questioning, jury number 5 initially responded, well, as you mentioned, according to when you listen, whatever you hear, so I think I'll give it a shot. As a result, a colloquy followed, in which the court explained to jury number 5 that regardless of her answer, jury number 5 needed to be positive in that response. When asked if she was positive that she could give both sides a fair trial, jury number 5 said yes, that she could be positive in her belief that she would be fair and impartial. Importantly, jury number 5's use of the word think in her response to the court's questions does not demonstrate implied or actual bias. Okay. Finding no bias, when juror replied, no, I don't think so, after being asked whether she might favor the prosecution, the prosecution's argument, their evidence, their witnesses, because you are a member of their office, and confirmed that she could acquit the defendant if she found the prosecution had not proven its case. This law right here, finding jury had no actual or implied bias, warranting relief when asked whether his experience as a police officer would carry over into petitioner's trial. The jury responded, well, sir, I would certainly like to be able to say that it wouldn't, and I would certainly do my best to see that it did not. Moreover, even if jury number 5's response demonstrated some initial ambiguity about her partiality, she affirmatively stated that she could be fair and impartial upon further questioning. Trial counsel's decision, therefore, not to challenge her was not deficient. Deficient. Rejecting this law right here, rejecting claim of ineffective assistance of counsel based on trial counsel's decision not to make a for cause challenge, where jury expressed doubts about his ability to be fair and impartial given his employment as a police officer, but subsequently answered in the affirmative upon further questioning about whether he could base his decisions in the case solely on what he would see and hear in the courtroom, and where there was no evidence in record that the court would have granted a challenge for cause, even if defense counsel objected. This law right here, holding that the decision not to challenge a juror for cause, when that jury expressed that she was sensitive to the issue, but ultimately stated that she could try to remain fair and impartial, did not amount to ineffective assistance of counsel, particularly where based on the juror's response to a hypothetical question posed during voir dire. The attorney may have reasonably inferred that the juror would be sympathetic to the defense strategy he planned to use at trial. This law right here. And this is finding no actual bias, where jury initially stated that he could try to be fair and impartial, and then subsequently agreed that he would leave sympathy and emotions out of his deliberations and decide it from the facts on this witness stand. Facts over emotions, okay? Evidence over emotions. That's exactly basically what they're saying, okay? All right. Let's continue. Okay. Goes on to say, concluding that district court did not err in failing to remove prospective juror for cause where juror initially expressed reservations about ability to be impartial, but later promised to try to decide the case based on the evidence presented, okay, with this particular law, okay? Now, upholding the denial of challenge for cause where a juror indicated he would do his best to decide the case based on the evidence presented. The defendant thus cannot show deficient performance or actual bias and fails both Strickland prongs. Now, juror number 7, okay, formerly prospective juror number 145, the defendant asserts that trial counsel was deficient in failing to challenge juror number 7 because she had heard certain information about the defendant's alleged crimes, okay? The claim is baseless. Ooh! Baby, the claims is baseless, okay? While juror number 7 advised that she was aware of who the defendant was and existence of a case against him, juror number 7 stated that she had not seen any documentary about the defendant and that her impression of the defendant was neutral, because most of the information you hear about celebrities are not always true. It's mainly either for or against the person. Juror number 7 also advised that she had not discussed the case with anyone or posted any opinions about the defendant online, okay, and made clear that she would remain fair and impartial in deciding the case, indicating that there was no reason she could not follow the court's instruction regarding the burden of proof and the fact that the defendant is innocent until proven guilty. Now, during the in-person voir dire, when asked whether she could put aside the very little she had heard about the case and rely only on the evidence in court, the jury answered, sure. Moreover, then asked if she promised that she will be a fair and impartial juror to both sides. Juror number 7 response was, of course. In these circumstances, the defendant cannot show actual bias and his ineffective assistance claim must fail. Dang. Now, in addition, the defendant cannot show that trial counsel's decision not to strike juror number 7 was not strategic. During trial, defense counsel sought to emphasize the defendant's musical talents and popularity as part of its trial strategy. Thus, trial counsel may have believed that juror number 7's knowledge of the defendant's music and her lack of knowledge of the Me Too movement made juror number 7 an attractive juror. Because maybe she was a low-key fan. Let's just be real. That's what they were hoping for. Maybe that she was a low-key fan. And with her being a low-key fan, she'll, look past a lot of stuff. In any event, in light of the juror's unequivalent responses, establishing her impartiality oh, y'all see the word. I'm all tongue tied. Impartiality, my bad, impartiality. The defendant cannot show actual bias or that the court would have granted a motion to strike. Now, juror number 8, formerly prospective juror number 147, the defendant claims that trial counsel was deficient in failing to challenge juror number 8 because he had heard about the crimes that the defendant allegedly committed. Okay. Notwithstanding such knowledge, juror number 8 advised that he had a neutral impression of the defendant and that he had no feeling toward the defendant. In response to other questions, juror number 8 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instruction. Now, during in-person voir dire, juror number 8 also answered each of the court's answer in an unequivalent manner, consistent with its ability to put aside anything he knew about the case. Okay, hold the government to its burden to prove the defendant guilty beyond a reasonable doubt and judge fairly and impartially. In these circumstances, the defendant cannot show actual bias, nor can the defendant show that trial counsel did not strike juror number 8 for strategic reasons. In the questionnaire, juror number 8 advised that he listens to the defendant's music and has no views of the case. Given juror number 8's other responses indicating that he had no knowledge of the Me Too movement and could clearly be fair and impartial, trial counsel likely believed that juror number 8 was a fan. What I say? Fan of the defendant's music and thus would be a favorable juror for the defense. In any event, in light of the juror's unequivocal responses establishing his impartiality, the defendant cannot show actual bias or that the court would have granted a motion to strike. Jury number 9, formerly prospective jury number 156, the defendant claims that trial counsel was deficient in failing to challenge juror number 9 because she had heard that the defendant had unknown issues with the law and had knowledge of the Me Too movement. In response to questions regarding whether juror number 9 was familiar with the defendant or any allegations against him, juror number 9 wrote, "Sounds familiar, but unsure," and that the defendant had issues with the law before, but couldn't tell you exactly what for. Juror number 9 also indicated that she had a neutral impression of the defendant because I know he's been arrested before, but don't know if he was convicted or not. I don't watch entertainment news or follow gossip, influencer sites, or about celebrities. In response to a question concerning knowledge about the Me Too movement, juror number 9 described the movement as the power structure of the male-dominated movie industry. Has turned on its head and indicated that she had not participated in the Me Too movement. In response to other questions in the questionnaire, jury number 9 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. Okay, I hope y'all doing good. All right, sorry I can't really check in on y'all, but I love y'all. During in-person voir dire, the court asked juror number 9 whether she could put aside any prior knowledge that she may have had about the case and decided it only on the evidence presented in the court, to which juror number 9 responded, "Yes, I can." In response to questions regarding whether juror number 9 promised to follow the court's instructions on the burden of proof, the defendant's presumption of the presumption of innocence, the law, and refraining from obtaining outside information about the case, juror number 9, as she did in the questionnaire, answered in the affirmative to all. promising to do her duty as a fair and impartial juror. The defendant has offered no evidence to suggest that trial counsel's decision not to strike juror number 9 was anything but strategic. As an individual who had a neutral view of the defendant, did not follow gossip sites about celebrities, and who had a relative who was convicted of federal crime and served 5 years in prison, trial counsel likely believed that juror number 9 would be a favorable juror for the defense. In these circumstances, the defendant cannot show actual bias or deficient performance, and his ineffective assistance claim fails. In any event, in the light of jurors' unequivocal responses establishing her impartiality, the defendant cannot show that the court would have granted a motion of strike. Juror number 11. The defendant claims that the trial counsel was deficient in failing to challenge juror number 11 because she had heard and read about the alleged crimes on the news. Specifically, in response to questions regarding whether juror number 11 was familiar with the defendant or any allegations against him. Juror number 11 wrote that she saw the case mentioned on the news when the defendant was first being investigated. Sorry, y'all. Sorry, y'all. She saw the case mentioned on the news when the defendant was first being investigated, knew that the defendant is a musician, and that there were allegations of misconduct lodged against him. Juror number 11 also indicated that she had a neutral impression of the defendant because I do not know enough information about the defendant or the case. In response to other questions in the questionnaire, juror number 11 made clear that she would judge the facts of the case fairly and impartially in accordance with the court's instructions. Okay. And those are the questions. Okay. All right. Hold on. I saw a question. This particular reading that I'm reading is for the new trial. We haven't even got to the acquittal response. This is just for the new trial. Okay. This is her response for the new trial. Okay. This is what she's saying in response to the new trial. We still have to read the acquittal, which I probably, to be honest with you, won't read that tonight because it's almost midnight here and we still have a few more pages. So I probably will read over it on my own time and then we'll come back on tomorrow and read some of the acquittal. Okay. Let's continue. Okay. Similarly, doing in-person voir dire, when asked by the court whether she could put aside any prior knowledge that she may have had about the case and decide it only on the evidence presented in the court, juror number 11 responded, yes. In response to questions regarding whether juror number 11 promised to follow the court's instruction on the burden of proof of the defendant's presumption of innocence, the law and refraining from obtaining outside information about the case, juror number 11 answered in affirmative to all, promising to do her duty as a fair and impartial juror. In these circumstances, the defendant cannot show actual bias or deficient performance. Juror number 12, okay? All right, let's see what their claim. Okay, they're saying that it was deficient because he had heard about the crimes that the defendant allegedly committed from various sources and had knowledge of the Me Too movement. Okay. While juror number 12 indicated that his somewhat negative impression of the defendant was a result of an emotional response to the nature of the charges against the defendant, juror number 12 also advised in the same response that he really never cared one way or the other regarding the defendant. Dang. Yikes. In response to other questions in the questionnaire, juror number 12 made clear that he would judge the facts of the case fairly and impartially in accordance with the court's instructions. Now, during in-person voir dire, when the court raised the fact that jury number 12 had indicated on the questionnaire that he had some information about the case, juror number 12 advised the court that it was just minor things in the press. Nothing I can recall any specific details. Sorry, y'all. Let me download this too. Okay. Hold on, y'all. Hold on, because my mouse is getting real sticky. My bad. Okay. All right. It wouldn't move. Sorry, y'all. It's tripping. Okay. Nothing I can't recall any specific details. Juror number 12 added that, in fact, the summary and questions included in the questionnaire provided more information about the nature of the case than what he had previously been aware of through any media coverage. For example, when asked whether, oh crap, hold on, y'all. Sorry, y'all. This mouse, I don't know if the battery is going dead, but it's tripping, big tripping. So give me a second. Let me just touch my screen. Yep, you woke up in time. Yeah, I'm okay. I'm good. Sorry, y'all. My mouse be tripping. Okay, it was tight. Okay, when asked whether he could put that information aside and judge the case based on the evidence presented in court, juror number 12 responded, "Of course," stating it most definitely is. When the court referenced juror number 12's statement in his questionnaire, that trial by media is worse than trial by jury. Subsequently, in response to questions by the court regarding whether jury number 11 promised to follow the court's instruction on the burden of proof and the defendant's presumption of innocence, jury number 11 responded 100%. Further, with respect to the court's inquiries about whether he could follow the law as the court instructed and refrain from obtaining outside information about the case, juror number 11 answered in the affirmative, promising to do his duty as a fair and impartial juror. The record thus clearly reflects that there was no actual bias on the part of juror number 12. They are just steadily knocking it down, okay? Knocking them down one by one, okay? Do you hear me? Knocking them down one by one. Okay. All right. Anyways. Okay. Oh, well, did we leave off? Okay. Trial counsel's conduct with respect to this juror was also not deficient under Strickland. First, counsel had a strategic reason not to strike his juror. In the questionnaire, juror number 12 advised that he had a friend who was related to Bill Cosby, and as part of his discussion of his opinion of Bill Cosby's sexual assault case. Both in the questionnaire and during the word-to-word indicated that until the end of the case, I have no opinion. So he had no opinion. Oh, yes, it is. Oh, yes, it is. And we ain't even got to the acquittal response. And that's been posted. This is just the response to the new trial. And we ain't even got to the acquittal part, which we may do that tomorrow, because I really think the acquittal is going to be very substantial. It's going to be a lot of but you know, if y'all hang in there with me, I'll do whatever y'all need me to do. Let's go. But yeah, it's going to be a lot of egg on a lot of people's face. A lot of people's face. A lot. Hold on. That's not what I was trying to do. Hold on, y'all. So I'm trying to go ahead and download the acquittal response as well. Okay. Y'all, the acquittal response is 109 pages. 109 pages. Yeah, we're not reading that tonight. We're going to have to read that tomorrow. 109 pages, people. Yeah, nah, we're not reading that tonight. 109. The acquittal response is 109 pages, y'all. We're going to do that tomorrow. But let me go ahead and finish this. We got a total of 45 pages. We're on page 30. Okay? So we're almost out there, y'all. Okay, I'm sorry. I'm going to key it into gear. Okay? All right. Okay. Adding that trial by media is scarier to me than a juror. Jury number 12's position regarding Bill Cosby case not only reflected his ability to keep an open mind unless and until he had all the facts, but also likely formed the basis of trial counsel's strategic decision not to strike juror number 12, given the nature of the Bill Cosby allegations. In addition, juror number 12 had a family member who was sentenced to 10 years in prison. A reasonable attorney could certainly have believed that jury number 12 would be a favorable juror for the defense, notwithstanding his somewhat negative view of defendant or knowledge of the Me Too movement. For this reason, in any event, in light of the jury's equivocal responses, establishing his impartiality. Hold on, y'all. I'm getting text messages. People blowing me up. Okay. Sorry, y'all. Any for-cause challenge would have been futile. Alternative jury number 9. Finally, the defendant claims that trial counsel was deficient for not challenging alternate juror number 4 as a result of her knowledge that the defendant was married to Aaliyah, and as he characterizes it, for making an ultimately challenge to alternate juror number 4 during trial for asking the court's clerk whether the clerk could obtain an autograph from attorney Gloria Allred, who represented certain of the witnesses at trial on her behalf. Even assuming Arguado that alternate juror number 4 should have been dismissed, notwithstanding the court's proper determination that this alternate juror did not deliberate. Dang. Yo. So she wasn't even on trial. Y'all see? Bone jangles. Trifling ass. Bone jangles. Pulling people that wasn't even on trial. So basically, she got a jury that wasn't even on trial, y'all. She wasn't even on trial. And she picking that juror's questionnaire out, and she wasn't even on trial. That daggone bone jangles, I tell you. And therefore had no impact on the verdict. The defendant cannot show prejudice from his selection as an alternate, okay? More important, however, appellant cannot demonstrate that he was prejudiced by the trial judge's refusal to excuse this Vernier person, I don't know, for cause, since prospective juror was never a member of the jury that convicted the defendant. Moreover, as the defendant concedes, trial counsel did in fact seek alternate jurors number 4 dismissal. As such, the defendant cannot show that trial counsel engaged in deficient performance under Strickland. Here we go. Finally, as reflected in the record and set forth in great detail in the government response to the defendant's motion for a judgment of acquittal, which is incorporated hereby reference, the evidence against the defendant on all charges was overwhelming, and the defendant has presented no evidence to demonstrate that the jury's verdict was based on anything other than the evidence presented at trial. Oh, I don't know if that's like, no, it's that. Okay, there. The defendant's claim that trial counsel's motion to exclude the jury was ultimately is baseless. Boom, 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 boom. While alternate jury number 4, oh, did we already, these are like the little numbers, y'all. Like when they have the little numbers right here. So I'm not going to read all of that. Y'all can go back and read that. I'm trying to get it, get her done. Okay. So yeah, I'll go slower. Y'all can go back and read that. Okay. Assistance of counsel claimed that trial counsels failed to strike jury who was allegedly equivocal as to whether she could hold the prosecution to its burden, and allegedly invents a state of mind likely to preclude her from rendering an impartial verdict. Lack merit. Finding that in the absence of bias, a petitioner cannot satisfy the second prong of Strickland because there is no basis to conclude that had the juror not been seated as a juror, the result of petitioner's trial would have been different. Okay. Accordingly, the defendant's claim that trial counsel provided inefficient assistance of counsel during voir dire should be denied. Dang, y'all, they are not playing. Okay, not playing at all. Let's continue. Dang. Hey, Kamiko, honey bunches of oats. The defendant was not denied conflict-free counsel. Here we go. Here we go. Relevant background. Pursuant to its obligation under United States, and y'all see that law, the government brought certain issues to the attention of the court regarding potential conflicts held by one of the defendant's retained attorneys, Nicole Blank Becker. I want to get on the camera so bad. Okay, I got to get on the screen for this, y'all. This is what we've been waiting on right here. This is what we've been waiting on. Hey, come get this commentary. Hey. All right, here we go. This is what we've been waiting on, y'all. Nicole Blank Becker. The potential conflicts raised by the government were set forth in the detail in sealed written submissions dated June 14th, 2021. The sealed June 14th, 2021 letter and June 24th, 2021, the sealed June 24th, 2021 letter, collectively referred to herein as the sealed letters and incorporated herein by reference. Okay. The defendant bases his motion on one of these issues, specifically regarding the possibility that Ms. Blank Becker entered into an attorney-client relationship with certain individuals, including an individual referred to the sealed letters as Jane Doe number 5, which we know as Azriel Clary, and herein as Jane. Okay. Another issue, also relevant to the instant motion, related to the individual identified at trial, okay, as Joy or Joycelyn, and is detailed in these sealed letters, okay? Goes on to say, following the government's filing of its Crusoe letter, the court appointed independent counsel to advise the defendant on the issues, and on June 17, 2021, the court conducted the hearing, okay, that we are familiar with, which was further adjourned to allow the defendant ample time to confer with the independent counsel. Remember, you guys, what's my Cashapp? It's at the bottom. My Cashapp is at the bottom of the screen, scrolling by, you guys. It's at the bottom of the screen right here, scrolling by. Okay, scrolling by. All right, if y'all want to tip me, y'all, for all this hard reading. And then it's right here too. This is my Cashapp right here. Yeah, this is denied. Let's go, y'all. Okay. Child, we already said this though, y'all. We said this. Okay. See, we said this. Bone Jangles just is an idiot. Okay. There was too much pages for her to go through, which was further adjourned to allow the defendant ample time to confer with the independent counsel. Remember, they actually took him away, and that was the time when we actually was able to hear from R.KELLY. Remember that? We heard from him. Okay. The court continued the hearing to determine whether conflicts existed and whether the conflicts were waivable by the defendant. In making its determination, the court relied upon written submissions and exhibits by the government. Ms. Blank Becker and Ms. Gloria Rodriguez, who formerly represented Jane as well, okay, as prefers of information by the government. Now, Blank Becker and Gloria, based on the information, the court determined that potential or actual conflicts existed with respect to the issues raised by the government, but that all the raised conflicts, including those related to Jane, could be waived by the defendant. Now, based on the findings, the court advised the defendant of each of the conflicts and relevant implications of those conflicts. Now, during the hearing, the court also advised the defendant that he had the right to conflict-free representation, but under the circumstances could waive the conflicts if he so chose. Relevant to the instant motion, the court advised, among other things, that Joycelyn, even though she were sick, never formally retained as their lawyer, she has confidentially obligations to them. Okay. Now, given the nature and extent of those communications and the content of them, she would have a conflict if she were to cross-examine either one of them. So that's one of the conflicts. Let's see what happened, though. The court also advised the defendant that Ms. Blank Becker could not rely on or share with the defendant or his other attorneys any privileged information she may have obtained from these individuals. Also relevant to the instant motion, the court advised the defendant of the implications of a possible conflict related to an allegation regarding Joycelyn set forth in the sealed June 14, 2021 letter. At pages 1 through 2, nothing that there was not much of a foundation for the allegation. Now, while the court did not make a specific finding as to whether Ms. Blank Becker had committed unethical violation by contacting Jane while she was represented by Rodriguez, now the court advised the defendant regarding the implication of such a violation as it related to Blank Becker representation of the defendant. The defendant advised that he understood all of the conflicts, and you remember, they asked several times, okay? Well, that's my old one, Brooklyn. That's my old one. That's my old one. My new one is right here. This is my new one. But yeah, that's my old one. I'll put it on the screen. Because it's scrolling down at the bottom. There you go. Okay. The defendant advised that he understood all the conflicts. Okay. Independent counsel also advised the court, and the defendant confirmed that she had thoroughly explained. I just said that. And discussed with the defendant each of the issues that was the subject of the hearing. Okay. Subsequently, the defendant at the court's request explained his understanding of each of the conflicts on the record as explained to him by the court and the counsel. Okay. Notably, the court also advised the defendant that he had two lawyers who were not conflicted, Daroe Kennett and Thomas Fornella. Did we not say, did I not tell y'all that she didn't even touch Azriel during the court? But see, Bojangles wasn't there. And they got rid of all of the original counsel. So this is what you get, you idiot. 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 Okay, idiot. Okay. Where was it? Okay. But that if he waived the conflicts, the defendant would be giving up the right to have Ms. Blank Becker represent him without a conflict of interest. And that means that if the defendant were to be convicted at a trial, the defendant could later claim that the defendant lawyer Blank Becker wasn't an effective lawyer. Because she had those conflicts or potential conflicts, when asked if he understood both of these implications, the defendant responded, "Yes, I do, Your Honor." Now, the defendant advised the court that he waived the conflicts and would continue with with Ms. Blank Becker as one of the retained attorneys. At the conclusion of the colloquy, I think that is, my bad, y'all. With the defendant, the court found that it had established that Mr. Kelly is fully competent and capable of making an informed decision, that he has been advised by independent counsel. Okay, that's important. This was not a court-appointed counsel. This was independent. Okay, so this is not somebody working with the man. Okay, this was not somebody just given, he chose this attorney. Okay, and that his waiver of these potential conflicts or conflicts is knowing and intelligent, and so I accept the waiver. At trial, the defendant was represented by 4 retained attorneys. You hear that? They're putting emphasis on retained because they wasn't court appointed. Okay, he chose these attorneys. So you can't now then say, "Oh, I don't like it. I don't want it." Oh my God, let's go. Mr. Kennett, Ms. Blank Becker, Mr. Fornella, and Mr. Calvin Scholar. During trial, Jane testified during the government's case in chief, and Mr. Kennett conducted the cross-examination of Jane. I just told y'all that. Y'all gonna stop playing in my face like I don't know this case, like I don't know this trial. pick and choose what I speak on. But I told y'all this. I said he didn't even touch her during trial. Let's continue. Legal standard. The Sixth Amendment right to effective assistance of counsel generally ensures that an accused may be represented by any attorney who will agree to take his case. Okay. And this is the law right here. A defendant has a correlative right to. Okay. And then this is, the little law right there. Okay. A representation that is free from conflicts of interest. Okay. The same freaking thing that old girl was trying to put out there. Okay. When a defendant's right to choose the counsel he wants conflicts with the right to an attorney of undivided loyalty, the choices as to which right is to take proceedings must generally be left to the defendant. Come on now. And he chose. District courts have an independent duty to ensure that criminal defendants receive a trial that is fair and does not contravene the Sixth Amendment. Okay. For that reason, when a district court is sufficiently apprised of even the possibility of a conflict of interest as the court was here, it has a threshold obligation to investigate the facts and details of the attorney's interest to determine whether the attorney in fact suffers from an actual conflict, a potential conflict, or no genuine conflict at all. Where defense counsel has an actual or potential conflict, the district court must determine whether the conflict is so severe as to require the attorney's disqualification or whether it is a lesser conflict that can be waived in the hearing. In most cases, where a defendant's attorney has a conflict, the defendant may make a knowing and intelligent waiver of his right to an conflict-free lawyer if he desires to continue the representation. Okay. In only rare cases, an attorney's conflict is unwaivably because it is so serious that no rational defendant would have knowingly and intelligently desired the conflict attorney's representation. Okay. Or because the conflict is so severe as to indicate per se that the rendering of effective assistance will be impleaded. Indeed, the Second Circuit has recognized only two categories of such per se violations of the Sixth Amendment that are unwaivable. Okay. Oh, okay. Sorry. Thank you for that. I will. Thank you. I will update the bottom. Thank you. Thank you for that. Okay. Okay. That are unwaivable where the defendant's counsel was unlicensed and when the attorney has engaged in the defendant's crimes. An attorney's prior representation of a government witness represents a potential conflict of interest. Now, this is because a lawyer owes an absolute duty of loyalty and confidentiality to both his current and former clients. Okay. Matter of fact, let me take that scrolling off if it's reflecting wrong information. And I'll just leave that up like that. Boom. This is because a lawyer, okay, we already read that, to both his current and former clients. Okay, and that's the law. Notwithstanding the limitations presented by this continuing duty of loyalty, a defendant can generally waive potential conflicts arising from his attorney's prior representation of a government witness. Okay. The Second Circuit has recognized that our cases support allowing waiver of the conflict that arises when an attorney must cross-examine a former client in order to effectively represent a current client. Okay. Such a waiver is allowed because although such a conflict might require a defendant to abandon a particular defense or line of questioning, he can be advised as to what he must forego. He can then seek the legal advice of independent counsel and make an informed judgment that balances the alteration in the trial strategy against the perceived effective of having to, perceived effect of having to get a new and perhaps less effective defense counsel. Where an attorney suffers from a waivable potential or actual conflict, the district court must conduct the hearing to determine whether the defendant will knowingly and intelligently waive his right to conflict-free, representation. Okay. The Second Circuit has considered a number of different factors in determining whether a conflict can be waived, including, among other things, whether disqualifying the defendant's chosen counsel would create real prejudice to the defendant based on the length of the representation or counsel's familiarity with the case. Whether there is a possibility that the attorney could be called as a witness at the defendant's trial or implicated in the defendant's alleged crimes. Whether the continued representation would conflict with the attorney's own personal, financial, or liberty in interests, as opposed to the interest of a current or former client. Whether if the conflict concerns the interests of another client, the attorney's relationship with the other client is continuing or has been terminated. Whether any other current or former client affected by the conflict has initiated or joined in the motion to disqualify defendant's choice of counsel, and the availability of measures that might limit the dangers posed by the conflict, such as restricting an attorney's cross-examination of a former client. Okay? And that's kind of what happened. It was a restriction of them doing the cross-examination. Okay? Y'all, I think I'm gonna slip in some of the quill information because we're gonna read a little bit of that. Okay, if y'all for it, okay, it's just gonna be on 2 hours and we're almost finished with this. Okay, so hang in there with me. I think I'm gonna read a little bit of the acquittal. Okay. A defendant challenging his conviction on the ground that he was deprived of his Sixth Amendment right to effective assistance of counsel as the result of a conflict must demonstrate first that the conflict was either unwaivable or that his waiver was not knowing and intelligent. And second, that he was prejudiced by the conflict. Okay. In other words, but for counsel, unprofessional errors, the result of the proceedings would have been different. Okay. Where a potential conflict exists, courts require that the defendant establish prejudice. Okay. And as we read, it was not. Okay. It was not prejudice at all. All right. Where an actual conflict exists, however, prejudice is presumed, and the defendant is required to show only that a lapse in representation. Good googly goo. Result from the conflict, okay? A lapse in representation means that some plausible alternative defense strategy or tactic might have been persuaded, and that the alternative defense was inherently in conflict with or not undertaken due to the attorney's other loyalties or interests. Okay, in equivalent where did I just go? Where I stop off at, y'all? My mouse is jammed. And my laptop thing don't work. So I have a mouse. And okay, there it go. Now the screen frozen. Okay. There it go. Woo! Okay. Sorry. Okay. I don't know where I left off at. I'm sorry. I don't know where I left off at. The screen had messed up. While actions of any member, I think I was there. I'm sorry. I was not. Y'all can see it. I'm sorry. Firm are imputed to every member of the firm. Such conflicts are not imputed on independent trial counsel. Okay. Analysis. Oh, y'all, and I think this is what she just submitted. Analysis. The defendant alleges that he was denied effective counsel because, no. Okay, so she just wanted some further information. My gavel. The defendant alleges that he was denied effective counsel because Blank Becker purportedly labored under a disabling conflict of interest that was imputed to the entire defense team. The defendant's argument is meritless. Ooh, these words. Meritless. Okay. It is based on incorrect claims that this conflict was unwaivable. Ooh. Calling out. And imputed to the entire defense team, which include 3 other independent counsel from different firms who represented him at trial. During this hearing, the court determined that Blank Becker may have developed a relationship of trust with Jane, which is Azriel, okay, and Joycelyn, okay. However, resulted in certain possible conflicts, including creating, among other obligations, a duty of loyalty to them. Assuming that Blank Becker, okay, relationship with Azriel amounted to an actual conflict, said conflict was clearly waivable. Several factors demonstrate that the conflict was waivable, including that the relationship was brief, limited in scope, and terminated prior to Jane's cooperation with the government. The relationship did not implicate, okay, did not implicate Miss Blank Becker's own personal financial liberty interest, and the defendant was represented by by 3 other conflicted retained counsel who could, and one of whom, in fact, did cross-examine Azriel during trial. So basically, it was no conflict because they never touched her. Listing factors weigh in favor of finding a waivable conflict. Okay, the defendant has proffered no facts, okay, from which it could be concluded that Ms. Blank Becker potential conflict amounted to an actual conflict of interest, nor do any of the case cited by the defendant support the notion that Ms. Blank Becker's conflict was not waivable. Instead, the defendant incorrectly conflates the issue. Sure did. Over-exaggerates, basically. The issue of whether an actual conflict exists with the question of whether the defendant may waive said conflict. As discussed above, It is well established that an actual conflict is not synonymous with an unwaverable conflict. Okay, and those are those little numbers y'all can read at your own discretion. Conflict was actual. It was also waivable. Indeed, it is the rare exception where an actual conflict cannot be waived by the defendant, and even if the conflict here was actual, it does not constitute one of those rare instances. Okay? Meaning what they put out there, it did not apply to this situation. Okay, they tried it, but it didn't work. Okay. Okay. Rather, the conflict represents one of the lesser conflicts, such as an attorney's representation of two or more defendants or his prior representation of a trial witness that is generally waivable. Holding that a defendant was entitled to waive a conflict created, y'all, we got 4 more pages, created by his counsel's prior representation of another defendant, despite assertions that counsel was blinded by his own substantial self-interest and finding that counsel had nothing approaching the sort of fiasco, self-interested that was presented. Okay. Considering that there was no indication that counsel had a continuing relationship with or an exceptional lucrative retainer from the other defendant, meaning Azriel. Holding that conflicts arising from trial counsel's prior representation of witnesses were waivable, given defendants' willingness to continue with current counsel despite their being barred from cross-examining counsel's former clients at trial, and the defendant's consent to measures that might limit the dangers possessed by conflicts, such as current counsel agreeing not to discuss his former clients with any independent attorneys hired to cross-examine them on conflicted counsel's behalf. Now, although counsel's conflict compromised his ability to be a zealous advocate for the defendant, it was nonetheless waivable. We have generally found that this type of conflict is waivable. In addition, any conflict related to Ms. Blank-Becker's conflict arising from any assumed attorney conflict relationship with Azriel was not imputed to the defense other counsel. The defense reliance on United States versus Stein in support of its claim. To the contrary, is misplaced. Ooh, baby. Baby, she said that's misplaced. Baby, you using it out of context. Baby, this don't apply to this. This don't apply, baby. This don't apply. This ain't it. This ain't it. Dang. Woo. Well, Stein helps that counsel's conflict was imputed to the other attorney in counsel's small firm. Independent counsel had no such conflict. Okay. Holding attorneys conflict from prior representation of trial witness waivable because, among other things, independent attorneys could be hired to cross-examine those witnesses on conflicted counsel's behalf. Okay. Ms. Blank-Becker is a solo practitioner, and the defendant's other counsel each have their own independent practices. Thus, Miser, Cannett, Fernella, and Scholar were not members of any firm, okay, with Ms. Blank-Becker, okay? All right, and remained unconflicted. Finding that conflict was not imputed to co-counsel, given that the record did not indicate a general partnership relationship between the attorneys extending beyond the representation of petitioner himself. Given that Mr. Canick, one of the defendants' 3 independent conflicted counsel, conducted a vigorous cross-examination of Jane at trial, the defendant has not shown that a lapse in representation resulted from the conflict. Even assuming the circumstances presented in actual conflict, nor can the defendant demonstrate that he was prejudiced in any way by Ms. Blank Becker's conflict. She still represented him accordingly, basically, if it was only a potential conflict. There can also be no question that the defendant was fully advised of the implications and consequences of the conflict related to Ms. Blank Becker's purported representation of Azriel. After being so advised, the defendant knowingly and intentionally waived the conflict and chose to keep Ms. Blank Becker as one of his attorneys. While Ms. Blank Becker's conflict prevented her from cross-examining Jane at the trial and from disclosing any privileged information obtained, if any, from Azriel to the defendant or defendant's other counsel, the defendant was advised of those consequences and was well within his constitutional rights to choose to continue to retain Ms. Blank Becker. A reasonable defendant may decide to retain a trust attorney even at the risk of losing those advantages after being properly informed of the risks and benefits of the consequences of the decision. Finally, the respect to the defendant's claim that Ms. Blank Becker suffered from a conflict under Fulton. Oh, you see that? The defendant is wrong. Ooh, yes. The defendant is wrong. Hey, yikes. Let's continue. She just said it. The defendant is wrong. Again, the defendant conflates. Ooh! Conflation. Okay? You out of proportion, baby. Oh, this is good. Two separate issues addressed by the court during the hearing. As set forth in the June 14, 2021 sealed letter, in an abundance of caution, the government expeditiously alerted the court to speculative information it had received from the defendant's former attorneys related to Joycelyn and Ms. Blank Becker. Joycelyn did not make any such allegations, nor did the government intend to or ultimately call Joycelyn as a witness at trial. So it still was no conflict either way it goes. Thus, even if there existed the possibility of a conflict under Fulton, no conflict was likely to or did in fact arise. None of the dangers outlined in Fulton, therefore, exists here. Nothing that the allegations were by a witness who was testifying against the defendant at trial, making it a different order of magnitude from other conflicts. Moreover, in the unlikely event that Joycelyn was to be called as a witness at trial by the government at the time, as set forth in Fulton, the per se rule advocated by the defendant applies only where the alleged criminal conduct is true or of the nature that it should be treated as true, not where the allegation is false. Child. Therefore, in order to prevail on this claim, the defendant must show prejudice. Given the lack of evidence before the court regarding the alleged conduct, there was no basis to treat the allegations as true, stating that the considerations related to the per se unwaivable conflict found in Fulton do not apply. If the allegations are clearly false, thus if a district court holds a full hearing and can definitively rule out the possibility that the allegations are true, a meaningful waiver is possible since the falsely accused attorney is conflicted only to the extent that she cannot cross-examine the witness regarding the falsity allegations. And that's what took place. As discussed above, the defendant had 3 other independent retained counsel, including Mr. Kennedy, who acted as lead attorney at trial and could have cross-examined Joycelyn if she had been called as witness. The defendant, therefore, has not and cannot prove any evidence that an actual conflict existed, or that if a potential or actual conflict did exist, that a lapse in representation resulted from, or that he was prejudiced in any way by the conflict. Accordingly, this court should deny the defendant's motion in its entirety. Thank you. Conclusion. Based on the foregoing, the defendant's motion for a new trial should be denied. And in that order. All right, y'all, we're going to take a sneak peek at the acquittal, okay? Let's head on over to the acquittal, okay? Go ahead and we're going to chop that up, okay? We're at 2 hours and 30. I may do a few minutes, okay, of this, and because I really don't want to rush through this. I want to read it in its entirety. Are y'all okay? Are y'all okay? Before I move forward, are y'all okay? Am I boring? Y'all, please let me know. Am I reading too slow? Am I stopping too much? Y'all just talk to me and let me know, okay? Okay. I'm sharing my screen, y'all. You good? Okay. Oh, Keep is. I didn't even notice you, Keep. Hey, girl. Dead man walking. Okay. All right. Okay. I'll read. Okay. I'm sharing my screen, y'all. Let's go. I'm so anxious, y'all. This is the acquittal. This is with the text messages and all that stuff. If they're going to talk about it, I don't know. We're going to see. We're going to look at the, what is it called? Okay. Oh, no, I'm not even sleepy. I'm up. I've been waiting on this. Now, I'm far from sleepy, girl. I'm up. I'm just making sure y'all okay and I'm not boring y'all. Yeah, let's go ahead and read and see what they're going to be addressing in this. And how we do that is by scrolling to the consonants, okay? So this is the acquittal. This is the big baby, okay? Table of contents, okay? It says the introduction, the factual background, Kelly and Enterprise, Kelly's genital herpes diagnosis, Angela, Aaliyah, Stephanie, Addie, Kate, Sonia, Alexis, Lois and Alex, Geronda, Anna, and Jane. There go Azriel, y'all. Fate, discussion. And then it says the racketeering conviction was sound. The government adduced sufficient evidence of an enterprise. Acceptable law. Members of enterprise shared a common purpose to engage in a course of conduct. The enterprise was distinct from its racketeering activities. The enterprise was distinct from Kelly. Ooh, y'all, look at this. I think they talk about the text messages, y'all. This is under the Racketeering Act and persuasion and coercion. Y'all I want to sneak so bad. Ooh, I want to sneak so bad. I want to sneak so bad. What, y'all want to be bad and sneak? Y'all want to be bad and sneak and see? Y'all want to be bad and sneak ahead real quick? Y'all want to sneak? What y'all want to do? Go into the text tonight. Oh, okay. All right. Let's sneak. Y'all want to sneak ahead? Okay. Let's sneak ahead. No, because I was going to. I got a breakdown for y'all. Well, let's just go. Let's see what they say. I gotta see first. Y'all let me know. Sneak ahead. Okay, we got one yes. Who else is up to sneak ahead? Who else is up to sneak ahead? I'm waiting to see what y'all say. Hit the hell out of the gavel. Hit the hell out the gavel. Yes, hell, why not? All right, let's run to it. Let's go to it. Let's jump to 75 real quick. Yes, okay. Let's be bad. Let's jump to it. Let's see what they say. Can you play? Need a cookie for intermission? Yeah, I'll play. Let me take an intermission and let me run over it real quick. Okay. All right. And we had a new member anyways. She's not here, but we're gonna do it real quick. Okay, real quick. Why not? How y'all like that? How y'all like that? How y'all like that? Okay, page 75. Let's jump down and see what they say. We're almost there. Almost there, y'all. Y'all ready? Okay. All right, y'all. We're skipping to the text messages, okay, in the conversation. Hey, G, long time no see. All right, y'all. I got it. Are y'all ready? Okay. Woo, here we go, y'all. Here we go. Okay. Let's go. Let's go. Racketeering Act 8B and 12B. Okay, persuasion, inducement, enticement, or coercion. Jane. Kelly argues that with respect to Racketeering Act 8B, the record is devoid of evidence that Kelly persuaded, induced, enticed, or coerced Jane to travel to California in April and May of 2015. As described above, however, the trial evidence showed that following their very first sexual encounter at the Dolphin Hotel in Florida, Kelly allowed Jane, an inspiring professional singer, to audition for him. And then Kelly told Jane he wanted her to travel to see him on tour, promising to teach her a few things, a few singing techniques. In subsequent phone conversations, he provided Jane with contact information for his assistant, Cheryl Mack, so that Mack could make arrangements for Jane to travel to see him in California. Jane did so, and Mack arranged for Jane to travel from Florida to Los Angeles and then other locations in California, all of while trial flights and hotels included were paid for by R.KELLY. As the Second Circuit has recognized, persuade, induce, entice, and coerce are words of common usage that have plain and ordinary meanings. Contrary, To Kelly's suggestion, the ordinary meanings of those verbs do not include as a necessary element the overbearing or transformation of another's will. Come on now. Indeed. A person may lead or move another by persuasion or influence to take an action to which she is already predisposed or neutral. A jury applying the common and plain meanings of the statutory terms to Kelly's conduct could thus readily conclude that Kelly persuaded, induced, and enticed Jane to travel to California with false promises of assisting her with her singing technique and by arranging and paying for her travel. Regardless of whether she expressed or felt reluctance, indifference, or for that matter, enthusiasm at the prospect of doing so. Recognizing in the context of a violation, okay, that a defendant can be found to persuade or entice even a seemingly willing minor. Okay. Yeah. It don't matter if she wanted it. It don't matter if her mama forced you to. She was a minor. You broke the law, idiot. At a minimum, such conduct amounts to inducement, which simply means to cause, which is all that is required of the statute. The requisite inducement is any offer sufficient to cause the woman to respond, and that since the appellant knowingly induced or persuaded the victim to make the trip, then she knowingly caused the victim to travel. Oh wait, let me see. Oh yeah, she knowingly the victim to travel by interstate carrier within the meaning of the statute. Faith. Oh, wait a minute. Is that it? Don't tell me that's it, you guys. Was that it? No. I think that was it. I think that was it, y'all. I think that was it. I don't think they addressed it. I'm gonna keep looking. Wow. Literally, y'all, that's it. I'm gonna keep scrolling. Y'all, they didn't address it. They don't address it. It goes into herpes, y'all. Can I show y'all something though? Nope. Okay, hold on. Let me see. Maybe we get into it with the Mann Act. Okay. I'm still reading, y'all. I don't see it. Okay. All right. It's some more. I found more. This is racketeering 9. I found more. Okay. So I found more. I don't know if it's going to address the text messages though. I found more. So let me put y'all on the screen. Okay. This is what they're saying more about Azriel. But I don't see nothing about text messages. Okay. Next, Kelly argues that there was insufficient evidence that Kelly did not subjectively believe that Jane was 18 years old when she had sexual contact with him in California. Again, the jury was free to credit Jane's testimony that she told as Kelly, sorry, that's not it. Kelly, her true age of 17 years old when the summer of 2015 ended and she needed to return to Florida for the senior year of school. And that this occurred before she returned home to Florida and before she returned to Chicago and then New York and California. While Jane's testimony on that matter is alone sufficient to justify the jury's verdict in that regard, there was additional evidence that supported Jane's testimony. And evidence was a letter dated September 19, 2015, and prepared by Jane's parents, authorizing Juice's mother to be Jane's guardian until she turned 18 years old. Suzette Mayweather testified that she met Jane in New York in connection with Kelly's concert at the Barclays Center on September 25th, 2015, and that Kelly then traveled to Washington, D.C., and then returned to New York on September 28, 2015. The following day, on September 29th, 2015, Kelly, Jane, and members of his inner circle traveled from New York City to California, based on text messages she wrote while she was in California in early October 2015. Jane recalled that she had sexual contact with Kelly during that trip, that she believed she was pregnant, and that Kelly urged her to get an abortion because she was only 17 years old. Based on that evidence, the jury was free to conclude, as it did, that Kelly knew Jane's true age at the time of the October 2015 trip to California, and that he did not reasonably believe she was 18 years of age or older. Like he did to Racketeering Act 8, Kelly also argues that the record is devoid of evidence showing that Kelly induced, persuade, entice, or coerced Jane to travel to California. But as with Racketeering Act 8, the jury was free to infer, as it did, that Kelly, who was 30 years Jane's junior, induced, persuade, entice, or coerced Jane to travel with him from New York to California and beyond, when he arranged for her parents to enroll her in a virtual high school for her senior year, authorized Juice's mother to serve as her guardian, paid for her return trip from Florida to Chicago, and arranged for Jane to accompany him and his entourage on travel by sprinter and or bus from Chicago to New York, from New York to Washington, D.C. and back, and from New York to California. At a minimum, it amounts to inducement, which simply means to cause, which is all that is required of the statute. The requisite inducement is any offer sufficient to cause the woman to respond, and that since the appellant knowingly induced or persuaded the victim to make the trip, then she knowingly caused the victim to travel by interstate carrier within the meaning of statute. Put another way, it was certainly reasonable for the jury to infer from those actions that Kelly sought to cause Jane's travel throughout the country with him, including with New York to Chicago. Finally, it is of no moment, as Kelly suggests, that Jane consented to traveling with Kelly or to sexually activity, as the Eighth Circuit once wrote. Okay, the gravamen of the offense prescribed by, and then the title is knowingly persuading, inducing, enticing, or coercing any woman to go from one place to another in interstate commerce for the purpose of illegal sexual activity, whether with or without the consent of the woman. Kelly contends that any sexual activity between Kelly and Jane in California was incidental to the purpose of the trip. Again, as with Racketeering Act 8, Kelly was free to make such an argument to the jury, but it is not a winning one for here. Where the court must, of course, view the evidence in the light most favorable to the government and drawing all inferences in the government's favor, as with Geronda, given Jane's testimony that she and Kelly regularly had sex, that Jane was just 17 years old, and the age difference of 30 years, the jury was free to conclude, as it did, that a dominating purpose of Kelly's transportation of Jane was so that he could have sexual contact with her. This inference is, of course, further, what is that? Patriced. But the testimony of Geronda, Faith, and others regarding the propensity as to which Kelly sought sexually activity. Finally, Kelly suggests that the government did not prove that Jane's travel from New York to California in October 2015 involved a facility of interstate commerce, and suggests that such a facility includes only a phone or a computer. The facility of interstate commerce was the interstate highways between New York and California, including I-80. An interstate highway is certainly a facility of interstate commerce. This woman was an idiot. Observing that interstate highways are facilities of interstate commerce. Okay. It don't, that's what I'm saying, y'all. That's pretty much it. Gets back into Geronda. Okay, here go another piece from about Azriel. Okay, but yeah, y'all, it doesn't state anything about the text messages. But okay, let me go on and read. Kelly argues that the government also failed to adduce evidence supporting a causal link between the threat of serious harm and Kelly's obtaining labor from Jane in the form of her having sexual contact with other women and men. Kelly's argument is not at all persuasive. At trial, the government introduced ample of evidence showing that Kelly used a combination of threats of force, threats of physical restraint, and a scheme, plan, and pattern intended to cause. Hold on, y'all. I'm gonna turn my camera off because it don't matter. Where am I at? Jane, that if she did, Jane and pattern intended to cause Jane that if she did not perform such labor, she would suffer physical harm and physical restraint. At the outset, Kelly established a pattern whereby he punished Jane if she violated any of his rules or otherwise interfered with his desires. She explained that beginning with when she was 17 years old, Kelly spanked her if she violated a rule, and that these spankings occurred every 2 to 3 days. The spankings left her bruised and sometimes with broken skin. I remember him saying that he has protocols and rules that need to be followed, and that a a spanking, was only to help me be better and remember the small things, just in case I was not remembering the things to do. Jane's testimony about chastisement by Kelly was corroborated in large part by letters seized from Kelly's residence and storage facility after his arrest. Kelly also physically abused Jane when he perceived that she violated one of his rules of desires. Jane also saw Kelly physically abuse his other live-in girlfriends and believed that he could do the same thing to her if she did not listen even more. On other occasions, Kelly left Jane in a room or on a bus for days at a time if she violated a rule. Series of letters containing embarrassing falsehoods and on occasions make videos containing embarrassing falsehoods and other humiliating activity. The government also introduced evidence showing the labor Kelly obtained as a result of coercive conduct described above. First, Jane testified that as a punishment, Kelly directed Jane to have sexual contact with Alex, also known as nephew. Jane explained that she did not want to have sexual contact with Alex and only did so because if she did not, she believed Kelly would have spanked her. Jane also had sexual contact with other women at Kelly's direction. She further explained she did not want to have sex with any of these women and only completed with Kelly's directions because he forced her to do so, including as a punishment, and that when she did not comply, he usually chastised her. Based on Jane's testimony alone, in which she expressively stated that she engaged in sexual contact with another man and other women because she knew that Kelly would spank her if she did not, there was more than sufficient evidence for the jury to find, as it did, that Kelly used threats of force, threats of physical restraint, and other tactics to obtain labor from Jane, including sexual contact with Alex and other. While unnecessary to recount for the purpose of this motion, Jane's testimony was further supported by a lengthy litany of other evidence, including among other evidence, Dr. Don Hughes' testimony about a series of coercive tactics used to control victims, and his testimony about coercive. Okay, we heard that. See here. This is about faith. And it's about the end. Let me see. Yeah, I knew it's about the end. Okay, so let me see. I think it's 244. Yeah. See, yeah, I don't think they addressed it, y'all. Let me go back up to the table of contents. Are y'all okay? Hope y'all okay. All right, let me see. Let's see. I don't think they addressed it at all. Okay, let's go to 33. Okay. All right, y'all. I think we got something. Yep, page 33. All right, y'all. Let's see what they say right here. Let's go, okay? All right. It says Jane was born on at the end of December 1997. Jane first encountered Kelly at a concert in Orlando, Florida, where Kelly was performing in April of 2015 when Jane was 17 years old and a junior in high school. At the concert, Kelly arranged for one of his employees or a member of his entourage to provide Jane with a piece of paper with his phone number, which number Jane thereafter called. During their initial communication over the phone, Jane told Kelly that she was an aspiring singer, and Kelly invited Jane to audition for him at the hotel in Orlando where he was staying. Jane also falsely told Kelly that she was 18 years old when she was, in fact, still 17 years old. Jane thereafter drove to Dolphin Hotel, okay, where Kelly was staying. When Jane arrived, Kelly engaged in oral sex, and Jane, and only after he was sexually satisfied did he listen to her audition. While at the hotel, following a frantic search by Jane's parents, security personnel knocked on the hotel door in search of a missing 17-year-old girl. Jane told the security personnel that she was 18 years old and presented the security personnel with her driver's license. The license provided proved that Jane was in fact just 17 years old, but the security personnel apparently did not confirm Jane's age and instead relied upon her oral representation. Following their encounter at the hotel, Kelly arranged for Jane to travel across the country to meet him while he was on tour. Jane traveled from her home in Orlando to Los Angeles. Kelly's then assistant, Cheryl Mack, arranged for Jane's travel. Kelly had sexual contact with Jane while they were in Los Angeles. And there, Kelly began to teach the rules to Jane, including that Jane wear baggy clothing, that Jane call Kelly daddy, and that Jane tell Kelly whenever she left the room. Jane texting her mother on April 29, 2015, be talking about rules 233E. Jane texting her mother on April 29, 2015, but he got me in sweats. He ain't like my tights showing my figure. GX233. Jane texting her mother on May 3rd, 2015. Everyone having fun. And Kel said, do not leave that room. From Los Angeles, Jane traveled to Stockton, California, and then Las Vegas. Jane and Kelly first had sexual intercourse in the hotel in Stockton. Kelly did not use a condom or other protection and did not tell Jane that he had previously contracted genital herpes. When she traveled to Las Vegas, Kelly introduced her to Juice during that trip. Jane also tried to run some errands, but Mac told her that she could not go anywhere without Kelly's permission after Jane finished her junior year. She spent the summer with Kelly traveling to shows, staying at his studio in Chicago. In August of 2015, Jane was diagnosed with genital herpes, leaving her so she could not walk, and she was devastated. Before she sought medical attention, she told Kelly about the severe pain she felt. Kelly arranged for Juice to take Jane to a doctor's office in okay, we already know all this. I'm trying to see if they go into any. They don't say anything, y'all. Hold on, let me come on the screen. They didn't say anything about the messages. Hold on, y'all. Let me change y'all, baby. I've been on here for a hot minute now. We finna agree on 3 hours here. They don't say nothing about it, y'all. Hey, Mama Rogers. Hold on. Sorry. Oh, what happened? It just kicked me out. Hey, Mama Rogers. I'm bouncing around. I'm really reading. We were trying to see about those text messages, if they addressed the text messages, and they didn't. They just referred to them again. They didn't really talk on them and elaborate anything in regards to it. Dang. I kind of knew that though. Because they're irrelevant. But I really wish they would have addressed it and said something. Can I show y'all something real quick though? I just thought this was interesting. I'm gonna wrap this up. We're gonna actually start over from the beginning of these documents. It's just 109 pages, and I'm not gonna lie. I was interested to see if they was gonna address the text messages. He's not gonna get a quill or a new trial. I mean, reading this, he's not. But know that the defense, they have an opportunity to respond to this, but I want to point out something to you guys, but I think I'm probably going to hey, Uncle Charles. Hey. I don't know. They have said plenty. They have said enough, but I thought they were going to go into details about, whatever, but I kind of figured, and that's why I was saying I wasn't too sure, because in the back of my mind I was like, I don't think they're going to say anything about those text messages because they're irrelevant. Like who, again, if they were factual, like he still did what he did. Yeah, it was a lot. I am going to do a recap, y'all. I'm going to slow everything down. But I just was going through some stuff, and like I did notes, y'all. And I was going to actually do this first. I did 2 pages of notes, y'all. Because I was like, if they don't talk about the text messages, I was. Which is too late to do it now. It's 1:25 in the morning here in Texas, and I still got to get up with my babies and get everybody done. Get everybody to school and stuff like that. But those that are just chiming in, we skipped ahead. We was trying to see about Azriel and them text messages. Y'all, sorry, spoiler alert, they don't address them. They talk about them. They bring them back up and refer to her texting her mother, but don't go into details as to if they were legit or not. So I don't know. It's like, I don't know. I don't know. That kind of killed my excitement. Oh, wait a minute. I hope y'all didn't block. Okay, yes. Okay. Hold on, y'all. I got a text message. Hold on, y'all. Sorry, y'all. Yeah, just happy he not get y'all. So yeah, just to sum everything up, which we're gonna read over these. I'm a respect y'all, and we're gonna actually be thorough with it. We kind of jumped around. Just some highlights as we wrap this up. He's not getting either. But again, the defense has the opportunity to respond to this. And then I think the government again, and then that's whenever, because I think they each get 2 opportunities, if I'm not mistaken. I gotta read back the docket. But just spoiler, they don't address the text messages, y'all. They don't address them. They refer back to them again, but they don't address if they are legitimate, how they got them. They don't, y'all. I wanted to hear about them. I'm not gonna lie to you, but in my gut, I was like, I don't think they are, because they're irrelevant. That's why I kept my mouth shut about it, because I was like, I don't want to put nothing out there, and then it's just kind of just out there, and I don't have facts to back up my claims. But they don't address it, y'all. Oh, fooey. But good news, this nigga not getting an acquittal, nor is he getting a retrial. And this is what I'm talking about. All that he should be free and he needed a new trial. No, he don't. I knew it. I'm just like, are we going to forget what was stated in the trial? Can I show y'all something just real quick before we wrap up? I got 5 minutes. Okay? Can y'all bear with me? 5 minutes. If y'all can't put a one, please put your ones in the chat. If y'all can bear with me, I just wanted to point out something to y'all. Judge Ben saying the parents were irrelevant, or they would have been put on the stand. I would have to agree. I just want to point out something to y'all real quick to put on your mind. Okay. Real quick. Y'all can tell I'm disappointed. One eye open, laying in bed. Oh, Quana. I don't want that. I want y'all to be well rested to be able to gather what I'm saying. And this is so, okay. Don't worry about it. Y'all get some rest. We'll get some rest. And I'll gather everything and I'll make it nice and pretty and put it in a little pretty little bowl for you guys, because y'all been hanging in there. And I mean, how many of us was looking forward to seeing what they was going to say about them text messages? Only to see that they really don't say anything. They just refer back to them. So I guess we're kind of back at square one, with everything. No, it's okay, because we're going on 3 hours, and I was going to literally break down all my little notes right here. But y'all know I'm about decently in order. We will come back tomorrow. And hey, Karen, we will. I know. I see the ones. I see probably like 1, 2. I see like 3 ones. But we will come back tomorrow. I probably will start first thing in the morning after I take the kiddos to the house. I mean, see, I need to go to bed. After I take the kiddos to school, it's real early in the morning though. I may come on and get things started, and then come back in the afternoon, read some more, and then come back this afternoon and read. This evening, and read some more to you guys so we can break it down. I'm upset. I'm disappointed. I wanted to hear. But they are sticking it to him. I can't lie about that. They are sticking it to him. Okay, it's no way, shape, or form around that. Good luck with him getting an acquittal or a retrial. Good luck with it. I knew it was more context, more levels to that. But yeah, we really didn't hear much about the text messages. They just kept referring back to them. So I don't know. I wish they would have said something like where did they come from? Like, give more, details about it. Are they legit? I mean, where did they come from? Which I did my extensive research, and I want to put something on y'all minds. Matter of fact, I'm gonna do my little part. I want to something just didn't feel right to me about these text messages. So I just wanted to point this thing out. Bear with me real quick. Let me do this. I'm just gonna do it anyway. I want to show y'all this real quick. Okay, real quick. Okay, real quick. Okay. What we are seeing right here, you guys, is testimony from Azriel. Okay, let me put myself down here at the bottom. This is testimony from Azriel. Okay. Now, what I just kind of was just like, let me just go back to these text messages. And mind you, as I was writing, the text messages were like a week. Really, seriously. It doesn't show like over time the text messages. It shows again, like she's known to do, like we heard, in her submission with the jurors, she only submits a little snippet of stuff, right? Okay, so cool, right? All right. I personally, if you ask me, this is what I believe. Now, y'all want to hear what I have to say? This is what I believe. I believe that some of those text messages were absolutely legitimate. I believe that the text messages, some of the conversations were pushed out of context, if you ask me. All right. However, I don't believe every conversation, every thread was legitimate. Okay. I don't. This is not nothing to do with my relationship with the Clarys, but just me doing my investigativeness with this and just reading the transcripts and listening to what's been put out there. And y'all tell me if it's on to something. So on page 782 of Azriel's testimony, okay? Well, actually, here, we'll do this. Yeah, 782 at the bottom of her testimony, okay? Well, we can start here. Right here it says, and where did you go after school? She said, after patron singers, I didn't go to any sports activities. I went to my friend Malika's house and I got dressed. Okay. So she went to her friend Malika's house and she got dressed, right? Okay. Because the perception of one particular text messages was her mom telling her what to wear. Remember that? How many of you guys remember that? Put your number ones in the chat, just so I can make sure that we're following along and I'm not, like hit by myself in this. Okay. They alleged that the mom, said that, hold on. Matter of fact, let me pull it up. Okay. Let me go to it. Bear with me, y'all. Oh my gosh. It's not pulling up my key factors. Hold on. Okay. I just wanted to make sure I have everything lined up. But see, this is what I was talking about. This is the reason why I wanted to wait to do this. Okay. Anyways. All right. Anyways, okay. So y'all remember that. Okay. So I'll just go off of memory. Okay, bump it. All right. So let me go back to Azriel's testimony, right? Okay. So y'all remember that the mom or in there, the mom was like, you know, you look a mess, right? Y'all remember that, right? Okay. So in this particular testimony of Azriel, she states she gets dressed at her friend's house, right? Right? So if we go by the text messages, you know, she gets dressed at her friend's house, right? Okay, cool. All right. So goes on to say right here that they asked her, you testified that you were at your friend's house and then you got dressed. Did you then go to the Dolphin Hotel? She said, I did. Okay. Then right here, they asked, do you remember what you wore when you went to meet the defendant that day? Azriel claims, she says, yes, I do. I wore black Kid Me heels and a pair of skinny jeans, dark blue, and a crop top that had mesh at the top. Please, please, please remember skinny jeans, okay? Just tickle my fancy, right? Skinny jeans, right? Okay. All right, let me see if I can find it. Okay. Okay. Let me find the text messages. Just want y'all to tickle my fancy with this. And I would have had this all in order. This is so impromptu. I'm sorry, y'all. Okay. So let me do this. Hopefully this, okay, yeah, this is the right one. I was like, hopefully this is the right one. Okay. Okay. Hold on, y'all. It's coming. Okay, they still in Geronda. Lord, hold on. Child. Okay, here we go. Okay. Listen to this. Okay. Yeah, I'm finna end this though. We finna end it. They didn't talk about the text messages. No. They referred back to them, but they didn't talk about it. Because at the end of the day, we all know on here that they were irrelevant, but I just wish they would have talked about it, something about it. Okay. This is what I was going to package for y'all, which I still am going to. But those that stayed in there, I want to give y'all a treat because y'all want to know what I feel about it, okay? So here's the thing. In Azriel's testimony, okay, we heard, yes, I do. I wore black Kid Me heels and a pair of skinny jeans, dark blue, and a crop top that had mesh at the top. Okay. So then let's go over to what Bone Jangles says in regards to the text messages with the mom, right? She claims, because you know they packaged it real thick on this, okay? She claims that Jane's mother encouraged Jane to tease the defendant, but not to do anything sexual with him, since he would then lose interest in her. Believing that he was speaking to an 18-year-old Jane, defendant texts Jane's mother that he was staying on the tour bus, but was going to get a hotel room for their privacy. Jane's mother then shared that message. first question to you would be, well, why did Jane skip school? Because she skipped school. She skipped the event. She skipped athletics to go there. Now, if the parents were privy to her going there and the mom knew, why was he so adamant about making sure she was alone? But anyways, that's not even the detail I'm getting to. My point is that in her testimony, okay, and we are wrapping this up. In her testimony, she states she wore skinny jeans, right? Okay. Then she goes on to say, they ask, what is that? She says, that is me prior to meeting the defendant. And they asked, and who took the photo? She said, I took it at that. I took that picture, right? Okay. She took the picture. Well, according to these text messages that was supposed to be coming from her mom, it says mom said, and this was in preparation to her meeting R.KELLY, right? I mean, that's what we were under the assumption, that these text messages were her preparing Azriel for R.KELLY, right? Okay. But listen to this detail. Be prepared to sing 3 songs. He said he will meet you and listen to your song. Please have your glasses off, hair to side. Mama knows best. Pretty hurts. And third, your choice. Don't yell. Put on a show, dance, grab his hand, shimmy, wiggle, sit on his lap, entice him while singing. Is all about performance. This, your chance and opportunity. Don't blow it. Jane's mother even told Jane not to look grown. All right, here we go. Take off that ugly ass lipstick. I told you, he don't want you to be grown. I told you to keep hair curly. That should look a mess. You need some jeans or shorts. You tried to look grown. He wanted you because you look young and innocent. That's why he won't, not a little girl trying to be grown. You're a damn fool. Pause. Did y'all catch that? Because see, I did. To keep hair curly, that shit look a mess. You need some jeans or shorts. Oh. On the contrary. Isn't it supposed to be in preparation of her meeting him? She already had jeans on by her testimony. So where did this text message actually fit into this equation? If we say it was before this meeting, then she was doing what her mama told her. She had on jeans already. So why would her mom prior to tell her to put on jeans? Oh, well, no, Whitney, this was afterwards. After what? Well, Whitney, she took a picture. Exactly. Again, if this message was from her mom and she took the picture to show mommy, I got on what you told me, why then in turn would her mom text her this and tell her you should have on jeans or shorts? Don't make any sense. Don't make any sense. It just don't make any sense. I want you smart bombshell. I'm just saying, don't make any sense. This is the reason why I say, but I'm not finished. Yeah, things that make you go, damn. Yeah, mom life. Yes. Your daughter had on what she was supposed to have on. Why did she look a mess? Why would you say, Mom, that I told you to put on jeans or shorts, when on the contrary, as Riel stated, she had on skinny jeans, blue jeans. And if her mom was privy to this arrangement to begin with and was aware of what she had on, and these text messages were from her, that wouldn't have been in the text message. But to me, if you ask little old me, these text messages were constructed before any of this. Why, Whitney? Oh, at one point in time, we hear that Azriel had access to her mom's phone at some point in time. That's how she saw these alleged text messages and conversation between her and R. Kelly. She had access to her mom's phone several times. Oh, well, Whitney, she also states that she left that phone when she went with R. Kelly. Oh, but not that iPod. Oh, but not that iPod. And as I told you guys when I did the R. Kelly tales, with the iPhone or Apple device, it syncs up with anything from an iPad to an iPod to an iWatch. And on all of your devices, you are capable of answering a call, answering a text message, answering anything that comes in. Y'all gonna stop playing with me. At a point in time, Azriel was against her parents. Oh, come on, somebody. See, we not playing no more. Yeah, we gonna wrap this up. It's almost 2:00 in the morning. Yeah. Azriel would have thrown the little doggy under the bus when it came to R. Kelly. She got several of the employees in trouble for trying to help her black behind, okay? They left phones out for Azriel to call, and she told on them. She sat on Gayle King and lied on her parents, only to come back around and tell the truth. She lied on the stand. I said it. On the contrary, while everybody else had their attorneys with her, Azriel did not. While everybody had family members there in support of, Azriel did not. Why? Because she was still in the process of going to, and by some means, take up for R. Kelly. So, when you ask me, if you ask me, since you asked me, because everybody been waiting on this, I do believe that some of the text messages were real. Because you gotta keep up the conversation so your mom can be none the wiser. Again, I tell you, if my child is not giving me any kind of reason or recourse to think otherwise or to think she's doing anything, I'm gonna keep it pushing. This is the very same young lady who came downstairs from after having sex with R. Kelly during the audition, act as if her parents were psycho for being concerned about her. Only to go on and continue a relationship. And also, are we going to forget that she talked to R. Kelly first? That's the real reason why she knew to go ahead and access her mama's phone, because his black behind told her, hey, I've been talking to your mama. Let me go ahead and get this paper trail started, okay? Because she already was locked and loaded. Them text messages don't make any sense before or after, especially when you saying that these text messages are supposed to be before her encounter with R. Kelly. Let's go with that. Why in these text messages would you say you look a fool? So let's go with she sent that picture. Why would you say you should have put on some blue jeans or some shorts when she had that on? It don't make sense. Because you also hear prosecution. Hold on, y'all. Hold on, y'all. My camera. I'm getting on the roll, baby. And it's like, okay. I'm gonna wrap this up, y'all, because baby, I gotta go to bed. I gotta get up in the morning. But I'm gonna put all this together for y'all. But you know, I gotta make stuff make sense, and I know. I don't know where I was at, but he had everybody do this. And if Miss Roger is still in the building, okay, he had Faith conduct text messages and sent to his phones. He also stated that he had engineers that could know who they were talking to. Do your research. Look up Apple and see the syncing of the Apple appliances. And if you can answer text messages, I'm going to compose all of that for you. But when I tell you personally, if y'all want me to get personal and now add my connection, they had no idea. But in the testimony, you hear Azriel say that she gifted her mom with an iPod. She gifted her mom with an iPod. And she had access to all of it, y'all. So why all of a sudden, when we hear that he does this to everybody, the rule goes out with these particular individuals? He did this with everybody. We heard how Diana Copeland had to wear a freaking robe and be butt naked. He had no respect for nobody. Nobody had to force anything on this man. Nobody. You had some shiesty parents, y'all, but no. But since they didn't address it, I'm going to. I'm going to tomorrow. T-Bama said, break it down. Y'all know me. I've been itching. I've been waiting. And y'all, like I said, I talked to the Clearys. I'm not finna lie to you like I am. But this ain't no information that they gave me. I did my own research. My husband tell you, I was over here. I'm excited. Y'all, pages. Me reading the transcripts. I'm a break it on down. It just didn't make any sense. And then the way that he was writing, hey, Tabor, love you too. Yeah, I'm still here. I'm about to head out. It just didn't make no sense. All the broken grammar and language and stuff like that. They had her, they had her sounding illiterate and retarded. Take off that ugly ass lipstick. I told you he don't want you to be grown. I told you to keep hair curly. Retarded like a mug. That look a mess. You need some jeans or shorts. You trying to look grown. He wanted you because you look young and innocent. Like, come on now. For real, y'all. That's what he want. Not a little girl. Not little. Girl trying to be grown. You're a damn fool. Really? It just don't make sense. It just don't make sense. If this is before her encounter with R. Kelly, how, Sway? How? And furthermore, it don't make sense because why it just don't make sense. I'm not gonna hold y'all any longer. We're at 3 hours and 23 minutes in this thing. It's almost 2 o'clock here. I'm gonna have to get up in 4 hours now. Y'all, I just, like I said, if they came out saying anything different, then I would have rolled with that. Like, for real. But now kind of just like, oh, why y'all didn't say anything? Because at the end of the day, we know this is irrelevant. But I always try to challenge your thinking and put something on your mind. I'm going to further break this down for you guys probably tomorrow. I just wowed you, Mom Life Love. Thank you. Yeah. I'm sorry, y'all. This was like word vomit. I was like, let me just show y'all something. And again, I'm not trying to pressure y'all or put my opinions on y'all or anything like that. But I'm like, where there's a will, there's a way. This man has been doing this since the beginning of time. Like, what are we talking about? Like, you know what I'm saying? Like, but anyways, y'all, I love y'all. And we're going to break everything down tomorrow. I promise y'all. I apologize for keeping y'all up so late. I will break this video down to different segments so it can be easy to digest. I will reiterate my points and give more depiction and evidence. I will be pulling up Apple information that I discovered on my own. I will show you guys an example, okay, where you can be in one place and tap into it. And I did it myself. I was telling my husband, I was using my niece's iPhone, right? And it was just going off. And I was like, why is this going off? I'm trying to record. This is when I was in the red screen in front of my restroom. And I would see her little text messages and stuff like that. And I was just like, what is this? She was like, oh, I'm signing to my account. Catch that. And one day, I captured one of the text messages and I pulled it down trying to be nosy because I'm an auntie. She was staying with me anyway. So I grabbed one, and you know, when I mean grab, you grab it from the notification, right? And this for my iPhone users. I grabbed it, and I was able to get inside that exact text message and text on her behalf if I wanted to, and it would have been reflective with her as if she did it. Why? Because it was attached to her Apple ID. You want to know why they overlooked them daggone text messages? Because they were just like, that's irrelevant. We don't even know if half that stuff is real or fake. We're going to dissect what we can from it and see this and the third. And they did just that. If you notice what prosecution used, maybe they went in there a little further with their forensics and said, okay, all this other mumbo jumbo, but I just wanted to tickle y'all fancy because, like I said, where there's a will, there's a way. And we're about evidence over emotions over here. And like I said, I really don't have legitimate evidence per se in regards to my theory. But just looking at a lot of the text messages and testimony, I'm like, that's weird. You got dressed at your people house, at your friend house. Okay. Only to show your mom and she reiterates something that you already had on. Makes no sense. It makes none. It don't even make no sense. And then nothing indicated her having any lipstick on, to our knowledge. I mean, I don't know. T-Bam says, yep, iPhone. I have iPhone and iPad. And they all sync, do they not? Everything. I remember my husband, I got him a watch. It was an Android. And it could connect to his phone. And I got it because, I mean, at work, he couldn't really have his phone. It's any device that got Bluetooth or that can connect. You got that. I could do that with flip phones years ago. Exactly. Queen Key says, I wonder how Alice is feeling now they put blame on her. I can't release this. She's devastated. She know that she didn't do this. Can you imagine being framed for something you didn't do? Okay? Devastated. Y'all got to understand these are people real lives. Okay? It'd be different if you know you did some stuff. but you know you didn't do it. You know you didn't do it. And you got proof. She got text messages corresponding with legitimate text messages, okay, of the day, and I just everything. But like I said, I was like, you know what, it wouldn't even be right coming from me because everybody, you know, think I'm paid off and all this stuff. I said, so I'm just gonna let it roll. But since they didn't talk about it, I'll talk about it and put my theory out there as to my perspective and how I think it rolled. But she's devastated. She's devastated. It really is messed up. It's devastating. She didn't do this, y'all. She did not do this. She didn't. But all right, y'all. I love y'all. We've been on here for 3 hours and 30 minutes. My husband is about to do the last call for alcohol. Done turned off the heater. Okay, and headed inside. And now I'm down to 4 hours of sleep. So I love y'all. I will be back here tomorrow. Yeah, we'll go from there. But where there's a will, there's a way. And be careful of the people that you listen to and the information that you receive, especially if you know that they're biased and geared towards a certain perspective without knowing all the facts. We're still at square one. They did not address the text messages. They referred back to them, but they didn't go into details. So, like I said, I'm going to put my theory out there. If you don't mind tickling my fancy, I love y'all. But most of all, God loves y'all. Y'all be blessed and be safe. I will absolutely see you guys tomorrow for sure. I promise y'all. I'll probably hit y'all 3 times tomorrow morning, afternoon, and then the evening, okay? And we're going to start from the very top of this particular document. I'm sorry that I skipped around, okay? But yeah, okay? So I'm going to hit y'all with this on the way out.
Why I do think this is going to allow, he's not going to win the judgment of acquittal. No. But his better chance might be in the appellate courts if an appellate judge sees it differently than this judge does. But this has all happened pre-trial already. All of these arguments have already probably been made, and the judge has already ruled it.
And that one I found interesting because the defense in that case is blaming the mother, saying the mother enticed Kelly. That's an interesting.
Well, that was a kind of a
argument.
common theme for these parents to kind of like sell their children.
Right, because they were looking for stardom. Again, was the enterprise his branding? Of course it was. Because think about this. Would that mother have pushed her daughter onto him if it wasn't for the fact that they were looking at stardom based on the fact they were going to be associated with Kelly? So again, the enterprise comes into it, and it shows it is independent and operates independent of the individual.
Don't tell me with this. I can't help.
Robert.
I can't help. You're killing me, man. This ain't not about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.
Man, y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me. Y'all trying to kill me. Y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me with killing me, man. Trying to kill me. Killing me, man. Trying to kill me. You don't want to believe it. Trying to kill me. Killing me, man. Trying to kill me. I hope this camera keep going. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it. Stupid R.KELLY. Fight for my life. Stupid R.KELLY. Do it. 30 years.
I'm Whitney. Keep it cute and get the boot.